to our Board of Supervisors meeting for October 25th, 2016. We are going to adjourn into closed session. Are there any public comments? Nope. Thank you. So we are now adjourning into closed session.
Mr. Chair?
Yes.
Do we know where Supervisor Wright is? Is he ill or not?
I haven't had any communication.
Okay. Thank you.
Thank you.
They're not here. We're going to continue that. You want me to pull it? Okay, yeah, I can do that.
All right. Good morning. Welcome to our October 25th, 2016 Calaveras County Board of Supervisors regular meeting. And first, I'd like to report out on our closed sessions this morning and fix the. First, I have to fix the live video feed here, so we won't have any noise. On closed session agenda, we had pursuant to Code Section 54956.9D1, conference with legal counsel, existing litigation, two cases, County of Calaveras versus Ross Thornton et al. And Eldorado Superior Court, case number SC 201500086, Dennis Ponte versus County of Calaveras et al. Calaveras County Superior Court, case number 12CV 38597, County Council Board action. And I'd like to mention also that Supervisor Ponte recused herself from this, and there was no action taken. Also on number 3 on the agenda is public employment pursuant to Government Code Section 54957B1, Environmental Management Administrator, APCO, Board action, no action taken. And public employee discipline dismissal release pursuant to Government Code 54957B1, Board action, and this is item number 4, and there was also no action taken on that. So with that, can please stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you. So we're going to go into recognition and acknowledgments.
Board Chair, I'm going to ask that number 5, adopt a proclamation recognizing local high school students for attending the American Legion Boys and Girls State be continued to the next meeting. I'll take responsibility for that. I should have given them more notice to be here, and it's a great group, and I'd like to have them here and give it to them.
That sounds good.
Could we have a motion and a second for that and a vote?
Yes.
I move that we continue number 5 until our next board meeting.
All right. Second. Can I have public comment on that, please? Okay, so I have a motion by Supervisor Kearney, second by Supervisor Wright. All in favor?
Aye.
Opposed?
Thank you.
So we have number 6. Diane?
Number 6.
That's all right, you can delay it as much as you like.
Proclamation recognizing Jason Batesor for his 14 years of outstanding service with Calaveras County.
Okay? How do we make this go slow? All right, so we have a proclamation that actually was, there's quite a few of the staff members had a piece of it. So I'll let Mr. Moss go ahead and start.
Proclamation recognizing Jason as patron for 14 years of outstanding service in Calaveras County. Whereas on August 1943 AD, Octavian, later known as Augustus, compelled the Roman Senate to elect him consul. And whereas on August 19, 1399, King Richard II of England surrenders to his cousin Henry, Jason's first son's name. And whereas on August 19, 1591, French King Henri, which is Henry IV, same name as Jason's first son, but different spelling, occupied Rouen. And whereas on August 19, 2002, Jason Batesor joined Calaveras County as a registered environmental health specialist and initiated an exemplary and award-winning Certified Unified Program Agency, or CUPA program, from its inception.
And whereas on February 13, 2007, Jason received, is that the one you just read? Yeah. Received Certified Program Agency Individual Award from California CUPA Forum Board in front of 1,100 plus individuals at the 2007 annual CUPA conference. The state recognized award that was given to only one individual per year. And whereas Jason served as chair of the statewide California CUPA Forum Board in 2011-2012. And whereas on January 5th, 2008, Jason was appointed by the Board of Supervisors as manager of Environmental Health Department. And on July 25th, 2015, was appointed by the Board of as the Environmental Management Agency Administrator and Air Pollution Control Officer. And whereas when the Butte fire occurred in September of 2015, Jason immediately worked with state agencies, including Cal OES and Cal Recycle, the California Conference of Directors of Environmental Health, CCDEH, as well as others to secure mutual aid as far away as Los Angeles County to evaluate properties before the embers cooled in the burn area. And whereas Jason further coordinated efforts with private enterprises in the removal of debris under the Butte Fire Disaster Debris Removal Program. And whereas in September of 2016, Jason was successful in bringing home a Calaveras County, the coveted Excellence in Environmental Health Award as voted on by members of CCDEH for the Butte Fire Response and Recovery. Now, therefore, it be proclaimed, the Calaveras County Board of Supervisors hereby recognizes Jason S. Batesor for 14 years of outstanding service to Calaveras County. And this is just, we couldn't put it all on one proclamation, so can I have a motion by the board, please?
So moved.
Second?
Okay, so I have a motion by Supervisor Kearney and the second by Supervisor Wright. Can I have public comment, please? No public comment? Oh, okay, I can comment. When Jason first told me, or I found out that he was leaving, I can only think back since I've only known him for 4 years. And then when he came into his position as director over there, or department head, immediately, soon after, he was thrown into the Butte fire situation. And I can tell you that I'm so happy he was here for that, because Jason was solidly for our community, and a very good communicator with all of us of the board. I can only imagine if he didn't take action as quickly as he did, what kind of results we would be seeing in our reservoirs, actually the state reservoirs right now, because of all of the hazardous debris that were out there, because there were many properties with burnt homes, but also a lot of other stuff, including, I remember one property had 55 truckloads of debris hauled out, just one property. So I think it was really important that we did that to be able to protect our watershed, our environment, and I can't imagine anybody else taking it on as he did. And he did it with a smile. He was good with people. He was concerned with our citizens. And he was a great communicator with administration and the Board of Supervisors. And that's all, it's every bit all we can ask. So when I first heard that he was leaving, I remember sitting here, and I didn't know until I heard it from everywhere else. All I could say is, it was hard for me to fight back my emotions on that because of the relationship I think that we've developed over the past couple of years. And so I think very highly of this, of Jason. So thank you, and here's your proclamation. Yeah, that should be pretty fun to hang on the wall there. According to
History here. Thank you very much.
Thank you for your service.
I appreciate it. Thank you.
Chair, but we need a vote.
Good job.
All in favor?
Aye.
Opposed?
Thank you.
Actually, I should oppose. This is your opportunity. Yeah. Okay, from here we'll be moving into public comment. So it's any item of interest to the public that is within the subject matter jurisdiction of the board and is not posted on the consent or regular agendas may be addressed during the public comment period. California law prohibits the board from taking action on any matter which is not posted on the agenda unless it is determined to be an emergency by the Board of Supervisors. If public comment is completed before the 30-minute allotted time period, the board may immediately move to the regular agenda. If public comment is not completed during the allotted time period, it will be continued at the conclusion of the consent agenda in order to provide opportunity for the remainder of the comments to be heard. And this morning we will have 3 minutes public comments. So who would like to be first?
Good morning. My name is Peter Baldridge. I'm the president of the El Rancho Loma Serena Homeowners Association. This association consists of 148 parcels of land committed by its governing documents to residential purposes only. The association has documented marijuana grows of commercial scale on at least 11 lots within its boundaries. The association is aware that 3 of these grows are not registered with the county. In other words, these grows are clearly in violation of the county's ordinance and a public nuisance. And I'd be happy to provide the APN numbers for these parcels if requested. Each of the 11 grows within our association violates our governing documents, which require that lots be used for residential purposes only, and for no purpose it violates state, federal, or local law. The association's board has taken action against these lot owners, including the imposition of heavy daily fines designed to discourage their commercial cultivation of marijuana within the association. However, the association lacks the authority to physically remove these grows. We have been patiently waiting through an entire growing season for the county to exercise its authority against these grows, which clearly violate the county's own rules. Now, as the growing season draws to an end, these unregistered growers will soon be harvesting and selling their crops, which will simply provide them with additional monetary resources with which they can buy up additional properties, lawyer up, and fight the association's efforts to drive them out. I come before this board this morning on behalf of the association to express our collective dismay at the county's failure to take action against the marijuana growers within our association who are clearly in violation of the county's ordinance. This lack of enforcement undermines our confidence in the county's oversight of marijuana cultivation in general.
30 seconds.
And encourages these growers who would flaunt not only our association's governing documents, but county ordinances and state law as well. We urgently request that the county take immediate action against these unregistered growers and restore to our community some faith that the rule of law still prevails in this county. Thank you.
Thank you.
Good morning, Supervisors. Sandy Meitraut here before you again to talk cannabis. While we await election results on measures C and D, we continue to have the urgency ordinance as our rule of law. I stand before you today asking why that law is not being enforced in areas that are fairly simple and very straightforward. I also live in El Rancho Loma Serena and remain a member of the HOA Board of Directors. Those parcels within the association who have registered under the urgency ordinance, as Mr. Baldridge stated, are being addressed by the association for violating our declaration of restrictions. It's a long and laborious process, but we'll get there even in the face of litigation. Those parcels within the association who have not registered are also being addressed, and we have requested a county assistance with these and have failed to receive it. As stated, El Rancho Loma Serena has 3 non-registered, non-compliant cultivators who have chosen to abstain from the rule of law in Calaveras County. By virtue of their size, they fall into the definition of commercial cultivator. These locations have been brought to code enforcement's attention, as well as law enforcement, several times and over a period of months. Nothing has happened. These individuals continue to grow. One even went so far as to admit their lack of county compliance in writing to the HOA board. This communication, which I can forward to you if you're interested in seeing it, was shared with another resource in the county. When I personally followed up with them, I was told simply, these things take time. Several months later, the clock is still ticking. Coupled with these violators, our HOA has had pets injured or killed by dogs running at large who are intended to protect farms. 2 cultivators exceed the dogs' county limits of 3, and one advertises themselves as a kennel without a license here in this county. As all of you know, I did not start out supporting regulated cannabis in Calaveras. I came to that place over time as a result of believing regulation would bring funding for enforcement. It did. However, it seems that enforcement has been somewhat selective.
30 seconds.
I've seen clear violations ignored, and I reiterate, simply been told these things take time. It might be time to spend some of the funds on contract staff augmentation to ensure, at the very least, code enforcement is properly supported and the county gets their site inspections done in an expedited manner. Does the board have any questions of me? Thank you for your time.
Sandy, would you forward that information to the board clerk?
I will.
And the gentleman that spoke earlier, would you forward that information to the board clerk? Thank you.
Thank you.
I also live in El Rancho Loma Serena. My name is Doug Beard. Good morning, Supervisors. I'm not going to be as eloquent as my predecessors. I think it's time for a little bit of blunt talk. It appears nothing is being done on a rather large group of people. It appears to me that there's a large group of people in the county, not individuals, but different organizations, that aren't getting anything done, and my taxes support that, and I'm unhappy about it. Now, either they're leaderless, or they have processes that impede the actual output of any work. Based on just canceling several hundred code compliance complaints a few months ago, I'd say it may be a process thing. To be clear, let's take two recent code cases. On March 25th, this was released to the code compliance people. A garage was added tied to an existing house without a foundation. A clear violation. It's still there. It doesn't appear that anything has happened. On June 13th, they were reported, another report was done of two structures that were built with no permits, large structures. Recently, it's been confirmed independently that people are living in them. Again, nothing's been done. To me, there doesn't seem to be anything is actually being done with any of these complaints. How is the process in the way of completing anything? How is it? I don't know. Or is there some systemic problem, like everybody's worried about covering themselves because of something they did? I don't know. I don't care. I just want the problem fixed. When the public can't know how something works, it's a problem. And in this area, I can't get a workflow description or even a cognizant acceptance of, oh yeah, well, we take care of it.
30
well,
seconds.
That's no good. I believe it's why nothing seems to work, is that there's no documented process. You can't hand somebody like a taxpayer, here, this is how you do it. This is how we do it. That's not possible. Nobody has that. So I would expect that you people will figure out what it is that's impeding these processes and get them fixed. Thank you.
Thank you. Any other public comments?
Good morning. My name is Michael Falvey. I live in Mountain Ranch. It isn't shoot from the hip, but this time I'm going to read what I have to say so I get it all across. My comments are in reference to the process for those appealing denials for a commercial cannabis growing permit. First off, I wish to commend the Planning Commission, Mr. Maurer, and his staff for their fine and complete work in addressing many questionable permits. I particularly commend them for following the letter of the law in reference to the urgency ordinance. Speaking of the urgency ordinance, let me say this. I was here for around 10 or 11 hours that day in May when the vote was held whether or not to invoke the proposed ordinance. At that time, there were hours and hours of public comment, as you well know. I would venture a conservative estimate of a percentage of 80% of the speakers who spoke in favor of the proposed ordinance were in fact marijuana cultivators. You know how packed the chambers were in here and outside. It was packed by representatives of the Growing Commission, Growing Community, and you will recall the standing ovation you received from the growers upon your approval of the urgency ordinance. They were truly happy with your vote and greatly appreciated it. Since the permit process started, there have been quite a few denials. Of course, the people denied have appealed to the Planning Commission. I have been to 2 meetings of the Commission where they addressed the denials and the appeals. As a person with what I would describe as a fair bit of common sense and one who could mostly see through the haze of confusion, I must say it is stupefying to me what appealers have come up with in their way of the reasons their appeals should be upheld. Lies, false evidence, photos of things that don't exist, forgery, you name it. Most of them are out-and-out lies. So if the appeal is denied, they play the game and appeal to you. I assume that's the last resort. Now my point is to why I'm making this statement. The growing community wanted, no, I will say demanded, that the urgency ordinance be passed. So that is what is in effect to legislate the growers for now anyways. It is incumbent upon you that unless an appealer can come up with truthful and documentable evidence that they deserve to be granted a permit to operate commercial marijuana operation and the appeal upheld, your responsibility to the citizens of Calaveras County, you must uphold the Planning Commission denials. As far as I know, so far, one person has had what seems to be a good argument against the denial. I believe he was up for review and will go in front of you or the Planning Commission. As far as the rest I have seen, there is no way any of those appeals should be upheld. I speak because my supervisor from District 2 has said a denied grower had good, and I quote, intent in reference to his out-of-compliance grow. So does that mean if a grower intends to honor 22,000 square foot designation but accidentally plants 44,000 square feet, he should be forgiven? No.
Mike, that was it. Thanks.
Okay.
Thank you.
I would appreciate the board and specifically my supervisor follow the letter of the law of the urgency ordinance.
Thank you, Mike. Any other public comments? Okay. Let's move on to our regular agenda.
Number 8 is from Information Technology to approve total project funding of $109,650 for upgraded data backup and recovery environment for county data centers, including quotes of $80,024.63 to SigmaNet, $12,586 to E+, and $7,795 to Quest.
Good morning, Supervisors. Stan Moore from Information Technology. Here to discuss one of the projects that we had included in the infrastructure upgrades in the teeter fund that has been set up for that. This is an improvement to an upgrade and improvement to the equipment and software that we use to make copies, to make backups of data, and to be able to recover should there be a need to recover with that data. Currently, we back up some data to disk. A lot of our backup data is done to tape. This environment will use much more of a disk-to-disk, which is a more efficient fashion. It's a faster fashion, and it is a higher quality fashion. It gives us better ability to recover should there be a need to recover. We've talked a little bit about this in previous sessions, that this will give us a redundant backup process. We've got 2 large data centers in the county, the main data center and the sheriff's office data center. Each one we'll have 2 instances. Each one will back up data for that data center and then send a mirrored version of it to the other data center. This gives us the ability, should we have a catastrophic failure of our backup equipment, in order to be able to recover. So we've got improved backup and recovery capabilities as a result of this. We believe that the investment will cover us for 5 years. That is based on the type of data and the amount of data that is currently backed up. Should there be changes in the type of data that is backed up, we may need more money as we go forward. The types of data that would cause us to overrun our 5-year projection is if we got into backing up video and a lot of images that take up a lot more data. Other than that, we believe that this will last for 5 years. The components that were mentioned here have all been competitively bid. There's another roughly $10,000 for professional services, licenses for the servers, and a slight contingency. Do we have any questions?
Any questions from the board?
Just to confirm that this was a budgeted item and it's coming out of the Teeter Fund, correct?
Yes, it is. It is coming out.
Okay. Any public comments? All right.
I'll make a motion to approve.
Second the motion.
I have a motion by Supervisor Ponte, a second by Supervisor Kearney. All in favor?
Aye.
Opposed? Thank you, Stan.
Thank you.
Item 9 is from the Assessor's Office to adopt the resolution authorizing the board chair to sign the application for open space subvention payment of $139,964.86 from the state of California under the Open Space Subvention Act.
Mr. Chairman, honorable members of the board, Leslie Davis, County Assessor. This is an annual request for your authorization to submit the open space subvention report to the Department of Conservation. I would simply point out that although the price tag on that is a shade under $140,000, you will not see a dime of it. Even if the state were to fund this program, which they have not funded for the last 8 years, we owe the state in excess of $300,000. So any payment that might come to us, should the state fund it, would be used to pay back that amount. I'm happy to answer any questions you might have. This is an annual request. You see me every October.
Question? Is this more or less than last year, say?
It's ever so slightly more.
Okay, any other questions from the board? Any public comments?
Yeah, House Gallant Taxpayer Association. Would it be possible to elaborate about the $300,000 that we owe?
Certainly, Mr. Chair, members of the board, about 10 years ago now, the Department of Conservation audited the Williamson Act subvention program of Calaveras County. At that time, they discovered some problems with the way the county had been reporting prime land versus non-prime agricultural land. And it was their determination that because of those historical problems, the county owed $313,543.44 for overpayments in prior years. I would point out they could only go back 4 years, statute of limitation. We had been accumulating a heck of a lot over the 20 years preceding that audit. Does that answer your question? Thank you.
Okay.
I'll make a motion to approve.
I'll second.
A motion by Supervisor Wright, second by Supervisor Ponte. All in favor?
Aye.
Aye.
Opposed?
Thank you.
Item 10 is from Public Works to adopt a resolution authorizing the board chair to execute a professional services agreement for construction engineering for the Railroad Flat Road over Esperanza Creek Bridge project between Calaveras County and Quincy Engineering Incorporated for an amount not to exceed $425,500 and for a term to expire December 31st, 2017.
Thank you. Jeff Krovitz, Public Works Director. As you may recall, at the last board meeting, you approved a construction contract to KW Emerson for the replacement of the Railroad Flat Bridge on Railroad Flat Road, crossing Esperanza Creek near the Warguard intersection. This item in front of you is a construction management, construction observation, construction reporting contract with Quincy Engineering to meet both state and federal standards required of our funding for this project. We went through a competitive bid, and the Quincy team was ranked the highest. And so we've negotiated through them, and what's in front of you is a contract for that construction support, construction management services.
Any questions from the board? Any public comments or questions? No? All right, we have a motion please.
I'll make a motion to approve.
Motion by Supervisor Wright,
I'll second.
second by Supervisor Ponte. All in favor?
Aye.
Opposed? Thank you.
Item 11 is from the Administrative Office to adopt a resolution approving the form of and authorizing the execution and delivery of the ground lease, the facilities lease, the trust agreement, the certificate purchase agreement, and the continuing disclosure certificate, approving the form of and authorizing the execution and distribution of the official statement, authorizing the sale of the 2016 refunding certificates of participation, and authorizing certain additional actions.
This item was previously brought to the board in a presentation a couple of meetings back, and the board gave direction to Administrative Office to move forward with the resolutions. So essentially, this is the item that will actually enact what the board gave direction for, and we're requesting approval of the resolution, therefore.
All right. Any board comments? Any public comments on this item? Okay. Can I have a motion, please?
So moved.
A motion by Supervisor Kearney,
I'll second.
second by Supervisor Ponte. All in favor?
Aye.
Aye.
Opposed? Thank you.
Item 12 is from the Administrative Office to adopt a resolution authorizing the sale and issuance of refunding bonds and related actions.
Similar to the previous item, once again, this was covered during the same presentation to the board. And again, the board gave direction to the Administrative Office to move forward on this item, and this resolution will therefore make this official, and we're requesting approval of this resolution.
All right. Board comments? None?
No.
Public comments? No motion, please.
So moved.
Motion by Supervisor Kearney,
Second.
second by Supervisor Olvera. All in favor?
Aye.
Opposed? Okay, number 13.
Number 13 is an item from Public Works. Authorize the board chair to execute a First Amendment to the professional services agreement between Calaveras County and Tetra Tech Incorporated for arboricultural and tree removal monitoring services due to the Butte Fire incident for an additional amount not to exceed $1,588,488 without modification to the existing term ending June 30th, 2018.
Thank you. Jeff Krovitz, Public Works. As the board may recall, in June of this year, we awarded a contract to Tetra Tech for arborist services. At the same time, we were pushing ahead with our partners at Cal OES and FEMA for environmental clearance for burn tree removal on public rights-of-way or county-maintained roads, as well as adjacent private property parcels with dead trees that have the possibility of falling onto publicly maintained roads. As we went through the federal environmental clearance process, there was discussion and consultation with a number of state agencies. One of the consultations was for endangered species with the United States Fish and Wildlife Service. The United States Fish and Wildlife Service identified 3 endangered species, 2 botanical, 1 amphibious, that needed monitoring during tree removal activities in order to protect habitat. We were given a series of mitigation and monitoring protocols that requires the presence on site during tree removal of a certified professional with the ability to recognize endangered species habitat, and affect protocols that would protect those habitats during the construction activities. Additionally, there was a federal consultation under Section 106 of NEPA for cultural resources, reaching out to some of our local Native Americans as subject matter experts, identified a number of sites of concern of cultural resources, and also made recommendations for cultural resources monitoring and potential mitigation if sites are disturbed during tree removal activities. This contract amendment allows us to place professionals under our currently existing arborist contract for those monitoring and mitigation activities during construction to meet federal guidelines. Also contained within this amendment are professionals for historic or archaeological resources. There have been identified through federal research between 10 and 20 potential historic sites that would be sites with developments such as old mines, old buildings greater than 50 years old, that will need additional monitoring during construction to make sure that we are not disturbing these historic resources. As we do not know, Public Works at this time, the specifics of what those mitigations and monitorings are for the historic or archaeological, we've put them in here as generic and based upon experience that Tetra Tech has on similar historic projects, have budgeted monies within this contract amendment to cover those activities should they be required through SHPO and FEMA in the environmental clearance for the removal of hazardous trees. So it appears to be a large dollar amendment in compared to the original contract. However, it is still the same subject and same work of the original contract. We have provided copies of this amendment to our partners at Cal OES and FEMA without objection, and so we are asking for board approval of this contract amendment to put ourselves in a position to begin work immediately upon receiving environmental clearance. Questions?
Questions? Is this going to be required of SHPA at some point, do you think, down the line, that we have these folks on board with us?
There has been some consultation between FEMA, the environmental branch, and SHPO, the State Historic Preservation Office, on the subject matter of this project, hazardous tree removal, Butte Fire. And there has been response that, yes, there will likely be some monitoring required. The only question that we have is, will the monitoring be required of historians or archaeologists provided through SHPO, or will our contractor provide that particular expertise? We wanted to cover all bases and not have to come back to board once we get these mitigations to further delay the removal of these trees. So that's why we have added it here as a look-ahead feature.
Okay. And then, you know, a lot of the work has happened now with Tetra in regards to identifying the trees and what's coming down and that sort of thing. This contract allows them to be present during the takedown of trees?
They are already required, and the original contract had them present not only at the takedown of the trees, but the loading of the trees on the truck and the transport of the trees to the debris management sites, as well as counting the trees arriving at the debris management sites, and then also monitoring the disposition of that debris material. So that was part of the original contract with Tetra Tech. And so the only thing that we've really added with this amendment is federal NEPA monitoring and potential mitigation to protect either endangered species, cultural resources, or historic resources that we may run into.
And any idea how Tetra Tech will hire folks for this?
They've already reached out to the Professional Services Committee and identified professionals. One of the conditions of approval from U.S. Fish and Wildlife is that the service, the U.S. Fish and Wildlife Service, would have approval authority based on resumes submitted. And I believe that to date, 18 resumes have been submitted and 17 have been approved.
Okay. Thank you.
Okay. Any other board comments? Any public comments? Okay. Entertaining a motion.
So moved.
A motion by Supervisor Olvera. Second. Second by Supervisor Wright. All in favor?
Aye.
Opposed? 14.
Item 14 is from the Planning Department to deny Appeal 2016-1084 and uphold the Planning Commission decision to deny Appeal 2016-1040 of the Planning Director's decision to deny commercial cannabis registration 2016-124.
Good morning. Gina Cathan, County Planning. You have before you an appeal of a planning commission decision to deny an appeal of the planning director's determination to deny a cannabis cultivation registration. Mr. Amin applied for a commercial cannabis registration. His packet was, in our opinion, near perfect. He had, his application was verified by the department as being in compliance with the ordinance. In addition, he had submitted additional documentation that was required for his certificate of registration, such as a state seller's permit, county business license, in addition to a the permit necessary for waste discharge through the Water Quality Control Board. We have yet to verify on site whether or not the actual site is in compliance, but according to all aerial photos, I would have no doubt that he would probably be in compliance based on our conversations, in addition to what we can see in the aerial photography. The problem is that Mr. Amin went to do his background check through the county sheriff's office, and while filling out his his questionnaire, failed to disclose an arrest. The arrest did not result in disqualifying factors. It was actually dismissed, and there was no conviction. However, the sheriff's office disqualified his questionnaire and disqualified his background check. So therefore, we denied the registration, and he has appealed that decision to you today.
Okay. Board comments?
There's also a notation in here that the applicant has a history of local sanctions, fines, and penalties. Is that part of the process? Item 15A, number 2.
In the report?
I'm reading 14.
Finds the applicant cultivation has convicted. Those were simply the sections that we cited him under for failure to disclose, and the arrest. Basically, in a nutshell, didn't complete the questionnaire as requested. So the application, much like filling an application out incompletely, the questionnaire was not filled out accurately.
So that's what that item 15A, number 2.
Yes.
Saying that the application wasn't completed.
History of local sanctions, fines, penalties, and violations of local ordinance. Yes.
Yeah. Any other board discussion? Okay. So now we'll go to the appellant.
Good morning. When I came to this county, I came with the intention to respect every regulation that was required for me, and I did.
Pardon me, sir. Could I ask you to do me a favor and
Yes,
hold
sir.
the microphone just a little closer to you?
Yes, sir. When I came here, I came with the intentions to follow every rule and regulation that was required of me, and I have. When I filled out the application, the questionnaire had stated a question, and I can read it to you. List any and all arrests or formal charges with or without disposition for any criminal offenses within the U.S. or any other country. I take responsibility for misunderstanding that question, but there's two things in this question that they wanted to list. The second thing didn't require me to, and I'm sorry, I'm really nervous right now. Sorry.
Question 1 has 2 questions. The first one is to list any and all arrests or formal charges with or without disposition. He did not understand what disposition means. Even after looking up the definition, we still didn't understand what disposition means in terms of this question. The second part is asking for any criminal offenses. So in context of criminal offenses, that doesn't apply to him because he doesn't have any criminal misdemeanors or felonies. He was arrested in his 20s for a fight, went to court, it was dismissed. That's the only time he's ever been arrested, and he's never even been pulled over for a traffic violation.
Mr. Chair, can I identify the speaker? Are you counsel?
I'm sorry, I'm Yasmin. My name is Yasmin, I'm his wife.
Oh, okay, I'm sorry.
Sorry about that. I wasn't expecting to take over for him.
I thought you might have been counsel.
No. So just so you guys understand where he's coming from, he had wrote not applicable. He didn't say no. He didn't get arrested. He didn't say yes either. That to me implies that he just didn't understand the question. Do you want to talk about your background check, your recent background check?
Yeah. I was recently accepted to Samuel Merritt University's nursing program, and with that you have to submit a background check. And I have the completed background check here if you guys want to take a look at it. Can I pass it to you guys? Would that be okay?
You can show it to us, but it's not going to apply here.
Okay, that's fine. Well, I completed a background check and I passed it. And the last 4.5 years I've been working as a nursing assistant for St. Rose Hospital in the intensive care unit. I've passed many backgrounds before, and I've never came across a question like that. In 17.95.165 of the ordinance, it describes what the disqualification is according to your ordinance. It says here that all applicants for a commercial medical cannabis cultivation site shall submit fingerprints and be subjected to criminal background checks conducted by the Calaveras County Sheriffs. And it says the registration may be denied or invalidated if the sheriff finds that the applicant for the cultivation site has been convicted of any felony or misdemeanor he deems to be reasonably related to the qualifications, functions, responsibilities, or duties expected of an applicant for the type of registration he or she is applying for. Even if they have a misdemeanor or felony, they can still hand out a permit. I don't have any criminal records. I've had one incident my whole life, and since then I've stayed away from any kind of trouble. I've stayed away from any kind of bad people, and I've never been in trouble. You know, I have a wife and 2 kids, and those are my world, and that's all I really need. I work in the medical field, and I help people for a living, so I didn't come here to be untruthful or try to deceive anybody or anything. I just misunderstood that question.
I just want to add, my husband approached me about this business opportunity, and the reason why I'm in support of this is, one, I'm a registered nurse. I have my master's, and I'm currently in school for my NP and my doctoral. And I believe that medical marijuana or medical cannabis helps a lot of people with opioid addiction. I currently treat a lot of cancer patients where I work. Not necessarily, we don't allow smoking, of course, but cannabis comes in different forms, as you may know, like oils and vapors. But I see a lot of families destroyed by narcotics. And my husband probably wouldn't mention this, but my brother-in-law is a paraplegic and is suffering with opioid addiction. And I wish that maybe he would have tried some medical marijuana, and that would have helped his pain and suffering, but he's too far down in this path that he can't come back out of it. So I just wanted to also mention that on top of looking at this question, because it was a little confusing when I first read it as well, I consulted a friend who is a police officer, and he had mentioned that this is a common question in the law enforcement applications. Given that we're not in law enforcement. It may not become, it's not layman terms for us. I can understand how it is for the person who's writing this questionnaire, but this questionnaire clearly is a little bit ambiguous for us. My only suggestion is that maybe the Calaveras Sheriff County Department revise the questionnaire so it's more basic with yes/no questions if they want to know exactly what they're getting out of their applicants. That's all. Thank you.
Any further comments from you guys? From the appellant?
No, sir. Thank you.
Okay. So now we have presentations by the members of the public, and they'll be limited to 5 minutes. Any public members wish to have a presentation on this item?
Al Segala, Taxpayer Association. I don't have a presentation, but I think we'd recommend that you approve the applicant's request, but go a little further, instruct County Council to work with the sheriff to make clear the definition of a requirement regarding convictions, arrests, so that the same mistake wouldn't occur again. Also, it would seem like convictions of a crime ought to be the disqualifying requirement rather than an arrest or an accusation for that matter. If there's a history, if the person has a history of maybe many arrests and no conviction, perhaps there might be evidence right there that the person wouldn't qualify. But it needs to be clear so that the same mistake doesn't happen again. This process is not supposed to be oppressive. And the sheriff is on record many times over of favoring a ban of marijuana. And so it's possible that that his enforcement of this ordinance is influenced by those convictions. But in any case, I think our county council should work with him to make sure this doesn't happen again and approve the applicant's request. Thank you.
Any other public comments here? Okay, so you have another chance to speak up before we move on to back to the staff. So the applicant, Ellen.
Yeah. I just wanted to mention that I've been in compliant with everything. I've paid every single fee that's been asked of me, from the cultivation fee, building permit fees, the public work fees. I also paid for the water board fees and also registered with the state. So I'm here to follow every rule and regulation you guys ask of me. Thank you.
Okay, thank you. Bring back to the staff, please.
Anything else? Nothing else to add?
So I just want to clarify, this was denied because of the specific background check that the Sheriff's Department.
Right. So what we've been seeing is disqualifications on two different areas. One, if they find through the background check that you have been convicted of a misdemeanor or felony, somehow related to, drugs, whatever, the sheriff's office can make that determination to disqualify you. The other disqualifications that we've seen have been those that have failed to complete the questionnaire accurately. So in this case, in the eyes of the sheriff's office, Mr. Amin failed to disclose an arrest. Although the arrest didn't result in anything, there was no conviction, they see that as a failure to complete and be honest with the questionnaire. So we've been seeing denials on both sides. One, disqualification because of actual felonies and misdemeanors, and two, disqualifications for failure to complete the questionnaire accurately. But everything thus far, his application is, this would be one through verification on site, through the site inspection. What we see in his packet today, he would probably be one of those that would get a registration of a certificate of registration, which is that final document.
Question for County Council. Originally, when we talked about background checks, the board gave direction, gave sheriff's support to look at a specific area of the background check. I know when the form came out, there were many more questions on that form. That was at, that was my understanding that was the board's direction. I see this is in section 2 of the application where it's listing arrests, etc. Section 1 deals more with what? We don't have that in our packet. Can somebody clarify what section 1 of the background check is asking for?
Hang on.
Because I believe it was section 1 is more or less what the board was wanting in past in our urgency ordinance, but when the application came back, we've got section 2 and 3 and so on.
Section 3. I think is, it's personal information.
Yes, it's personal information. It's part of the packet, and it's on page 473 of the overall board packet item. That board packet item. Yeah.
It just asks for basic information such as your name, aliases that you've used, physical address, mailing address, telephone, email, date of birth, height, weight, social security number, other addresses that you might have
Section 1 then. Okay, then section 2 is dealing with
the questions, the clearance questions.
And we were interested in development of the urgency ordinance related to convictions, if I recall. Not
Correct.
necessarily arrests and other things, more or less what the final outcome was by a court.
Correct.
Okay.
Okay, any other questions from the board?
Mr. Chair, I have a question. Question of Mr. Amin. Mr. Amin, did you actually complete your application, or did you have assistance from somebody, counsel, your wife?
Me and my wife completed the application.
Did you thoroughly read through it?
During that process, the submission date for all the application was short, so we were scrambling to get everything together. To be honest, the last thing I thought I had to worry about was a background check because I knew that I didn't have any record or anything that would withhold me. So I was more worried about being in compliance with everything on the operation as far as, 75 feet back from property line and all that stuff. So I was worried on that stuff than the background check because I knew that my background was clean and I didn't have anything that would withhold me from that.
Do you remember specifically reading a couple of sections? One applying to reporting any arrests with or without disposition. Do you remember reading that on the application?
I read the term disposition and I read the question. I did.
Did you understand it? I understand that you were confused when you answered that. Is that correct?
Absolutely. And even till this day, when I look up the definition of disposition, I go back and revert to that question, and I don't know how that question enters that sentence as far as what it's asking me to do. To me, I just figured in my mind that I don't have a conviction or any misdemeanors or felonies, and so that's how I went about it, and that's how I answered it. And honestly, that's the one portion that I didn't go over with my wife because I figured I'm clean, I'm going to pass this, no problem. And so I didn't go over that with her, but the rest of the application, me and her went over it together.
Do you recall reading a section regarding perjury, regarding the answers to an application on that form?
Perjury?
Was there a section that applies to perjury, getting false information on this application? Do you remember that?
No, sir.
Okay. Did you actually sign the form yourself?
I did sign the form myself.
And did you know that there's an acknowledgement, if there is or not, of understanding all the information that you're providing and the questions being asked?
Yes, sir.
I have no further questions.
Any other questions from the board?
Now, our urgency ordinance did not lay out the questions on the questionnaire, correct? Those were developed by the sheriff?
That is correct. The questionnaire was developed by the sheriff's office. And I just want to clarify so the board is clear. There has been discussion about background check and the process for the background check. And under the urgency ordinance, that's required under 1795, 165, 10, 8. But I wanted to remind the board that the background check is not the basis that is before the board. The basis is section 1795.170, and that indicates that cannabis registration may be invalidated by the planning director for the following reasons. 4 specifically says that the application for registration contained false or misleading information. So the issue before the board is whether the information on the background check form rises to false or misleading information for purposes of section 1795.170.
Thank you.
Okay.
But the false or misleading information would be in response to the questionnaire devised by law enforcement.
Correct.
And we did not instruct them on how to do that.
Correct.
Okay, what did we instruct the sheriff in our, without me going back and reading it and looking at it, on our urgency ordinance when it came to doing these background checks?
Ethan Turner, Deputy County Counsel. The ordinance directed the planning director to consider the sheriff's recommendations with regard to background checks. And it was if they had a marijuana-related felony, or a history of fraud, or code compliance issues, or dealing drugs, basically. And so the sheriff could make a recommendation based on arrests and convictions. And in this case, the sheriff has made a recommendation that the application should be denied because he inaccurately filled out the application. So as Megan succinctly stated, the question really is whether or not you guys think Mr. Amin deliberately gave false and misleading information. And if he did not, you can grant his appeal. If you think he did, then you should not.
I would still like to know, though, the question on what we asked. Can we answer that?
You want to know the actual language of the urgency ordinance?
Yes.
Certainly, I can read that for you. So specifically what it states is that all applicants for a caregiver medical cannabis cultivation site or commercial cannabis cultivation site shall submit fingerprints and be subject to criminal background checks conducted by the Calaveras County Sheriff. The registration may be denied or invalidated if the sheriff finds that the applicant for the cultivation site has been convicted of a felony or a misdemeanor he deems to be reasonably related to the qualifications, functions, responsibilities, or duties expected of an applicant for the type of registration he or she is applying for.
So it speaks specifically to conviction.
Thank you.
Okay. Any other board comments? All right. So we have surrebuttal by member of the public. Anybody in the public wishes to comment on this further? No? Okay. So I'm going to close the appeal hearing and bring it back to the board for discussion. So the appeal hearing is now closed, and bring it back to the board for discussion.
Well, I acknowledge what the sheriff is looking at, and I understand to where there's, I don't know, for lack of a better word, a misunderstanding about arrests, formal charges, etc. You know, the urgency ordinance was pursued based on convictions, and so I have a difficult time with this particular situation because I don't see any convictions listed here. And an arrest is one thing. I have some concerns with the form as well. I don't think it's clear. I think it's asking for a lot of information that was not directed during the urgency ordinance period. And I'm in support of granting Mr. Amon's appeal.
Anybody else wish to comment? Okay, can I have a motion then?
I make a motion to grant the appeal of Mr. Amon.
I have a motion by Supervisor Ponte. Do I have a second? All right, so dies for lack of second. So I need another motion.
Mr. Chair, I move that we deny the appeal of Mr. Amin based on the evidence presented to the Planning Commission and to this board.
Okay. I have a motion to deny the appeal by Supervisor Calaveras. Do I have a second?
I second.
A second by Supervisor Kearney. All in favor?
Aye.
Opposed?
No.
No.
3-2. Okay. So the appeal hearing on that one is over. Can we move on to the next one, please?
Moving to item 15, there's the Planning Department, uphold the Planning Commission's denial of 2016-1081 Dickinson Commercial Cannabis Registration Appeal.
Good morning, Board. If you could just give me one moment for this to warm up. Good morning, Darcy Gallart with the Planning Department. Before you this morning is an appeal by Stephen Dickinson on behalf of 20 Farms regarding the denial of commercial cannabis registration application. The project site is located at 2385 Wagner Road and Railroad Flat. It's approximately 2.5 acres. And the appellant also owns the adjacent parcel where he has another cultivation operation. The various reasons why this application was denied by the planning director were due to inaccurate photographic evidence, The photos that were submitted with the cultivation registration application were actually for the adjacent parcel. The second reason was that the receipts that were submitted with the initial application included names of an individual that was not associated with the registration application in any manner. Therefore, staff could not connect that the supplies that were purchased by those receipts were for the actual cultivation site. And the third reason was due to a lack of evidence to support the requested 16,355 square feet of cultivation area. On the screen before you is an aerial image of the site where cultivation was depicted to occur in the registration application information. This image is actually dated June 10th of this year, and this is the aerial imagery that the county flew over. And at that time, it fails to support any cultivation that might have occurred on the site, totaling 16,355 square feet. There is potential, once we measured it out, that possibly it could have been about 6,000 square feet of cultivation site in that particular area. The receipts that were submitted, March and April receipts, were for supplies such as wood, for construction of a fence. The gentleman's name that showed on the receipts, it came about that he had established accounts and he knew the appellant, and therefore it was easier for him to just purchase items underneath that gentleman's name because he already had those accounts established. And then one of the other receipts that was submitted for the other adjacent registration site as well. So the appellant provided some supplemental information for the Planning Commission to consider, and that's what you're going to see in these next few photographs. So this was information they submitted after they had filed their appeal with the Planning Commission. It was presented to the Commission at the meeting. So there's a photograph showing some grading, photographs that were dated April 19th and May 4th, showing some plants in the ground on the site. And the claim that the appellant made at the hearing was that the registrant was directed to change his square footage to the maximum allowable for the ordinance and the application, and that the forms were a little misleading, and that it stated that you could apply for a maximum versus what you actually were cultivating. He claims that his original estimate is 10,500 square feet, although the application again showed 16,355. And he stated that he would be willing to agree to a cultivation site anywhere between 6,000 to 8,000 square feet. After taking the public testimony and listening to the appellant and his legal counsel, the Planning Commission's findings for denial of the appeal were as follows. They stated that there was no confusion in the ordinance, that it's very clear in terms of what someone should be asking for regarding the maximum allowable canopy on a site. The registrant had registered for a mixed light operation, which you would assume you would see something such as a hoop house on the project site or a greenhouse, and there's no evidence of a mixed light operation on this particular site. There were some additional receipts and photographs that were provided, and the Commission stated that these items that were received could not be considered into the record because all evidence should have been submitted by June 30th. So I wanted to provide for you the most current aerial image that we have to date. This is dated sometime between late August, early September. So you can see now what appears to be some rows of plants. You can also see off what appears to be maybe some newer plants in the ground. It looks like a little bit of rows off to, we'll just call it the northeast part of the project site. So that grading and those plants, if you look at the June 10th aerial image, are not there. So I'm talking about, I wish I had my pointer, I'm so sorry. It looks like a green vegetation area, and if I scroll back, it now looks like it's been graded. Looks like there might be some rows of plants planted there. So there's a difference between the June 10th aerial versus the August, September aerial as well. Therefore, based upon all the information we have, staff is still recommending denial of the appeal, upholding the Planning Commission's denial. The Appellant did submit some supplemental information on October 3rd, which is part of your packet. It should be noted that the information that's in there that's contained in Exhibit A of that supplemental information is information the Planning Commission saw. Everything else that's in there, photographs and receipts, the Planning Commission were not presented with that information, so they did not see that as part of their consideration. It's my understanding that the appellant's legal staff has a PowerPoint presentation to give as well if the board would like to consider seeing that. That concludes my presentation, and I can answer any questions you may have.
Any questions from the board?
Not at this time. Not at this time, but I reserve the right to, if I will, question both parties in this matter. After hearing the other presentation, request a small break.
Right now?
Mr. Chair, 10:30.
Sure. All right, so we're going to take a 5-minute break.
Allows kind of people to set up what they have the presentation.
Let us continue with presentation by the appellant.
Mr. Chair, I have a small request. Council, would you remind the board that we are to hear evidence that was presented to the Planning Commission? Any additional evidence should not be considered at this time. Is that correct?
The appeal before the board is to consider any and all evidence that was in front of the Planning Commission.
Okay, thank you.
Good morning. My name is Roy Stanley. I'm the attorney for Stephen Dickinson and the Twining Farms Collective. And we're going to talk about appeal number 2016-224. We had a little technical difficulty, so we're not going to have the audio visual, but we're going to do it old school. We're going to do it on paper. Okay? We've gone through some of this already, and the applicant owns a large parcel that actually has a large piece of property that has two parcels on it. One is 2364 Wagner Road. The other is 2385 Wagner Road. This particular appeal concerns 2385 Wagner Road. He does have and successfully registered a commercial cannabis operation at the 2364 parcel. And these things were done at the same time. Some of the elements of the property are shared. You'll hear about a shared fence that surrounds the perimeter of the property. Which is one of the reasons why there's duplicate receipts and stuff of that nature. So they actually bought this property in 2013 and began to prepare for cultivation in 2015, late 2015. Some of the preparation included upgrading existing facilities and certain shared property elements, fixing some of the small houses that's on the property. All of those things are commensurate with being in compliance with the medical cannabis registration ordinance. If we go to number 3, as Darcy told you, there was a denial of this particular application. There were 3 specific reasons listed, and those reasons were there were some duplicate photographs, the receipts listed the name of a person not associated with the application, and the application listed a cultivation area larger than the area shown on the area photographs. I want to step back a little bit and explain why we approached the Planning Commission in the manner that we did. We understood from the ordinance that it seemed to us they needed supplementary information to either clear up some of the discrepancies or to corroborate what we were saying in the application. And so much of the Planning Commission appeal was concerned with giving that commission more information as to what Mr. Dickinson had going on the property and the operation that he was doing. What we did not address specifically at that time was the actual application and the sufficiency of the evidence in that application. And we're going to go through some of that today, and we believe that the application itself actually contained everything that he needed to be registered. Moving on to page 4, there is a due process issue here. At the Planning Commission, it was stated that they weren't allowed to accept any other evidence. We disagree with that. We believe that the Planning Commission, in their charter on the ordinance for the appeal, specifically says that the Planning Commission and the applicant or the person appealing should present all relevant and known facts to the Planning Department staff and Planning Commission. So, looking at the ordinance, our belief was they want us to bring all the information that we have in regards to this particular application, if there's more receipts, if there's more clarifying photographs. And our belief was that that information would be looked at in terms of its actual substance and whether or not it proved that Mr. Dickinson's application that he actually had the operation that he had on his property. But that was not done. None of that evidence was even considered, and it was basically denied on the basis that they couldn't look at anything else that was on the application. But I want to talk specifically about the application itself. Our technical difficulty is going to make it a little difficult to see some of the pictures and things, so we do have larger photographs you can look at. But I want to go specifically into the application itself. And if we look at, I'm going to go to page, I'm going to skip to page 6 just for time. I want to look at specifically each cause for denial. The first was that there was, as Darcy said, there was another person's name listed on the receipts. The receipts were submitted. There were two receipts submitted. There's actually a picture of those receipts on your slide. I believe it's number 6. And there's a name Lawrence. It's Lawrence Rangel. He's actually Mr. Dickinson's neighbor. And as she explained, he has a contractor account at a number of different supply stores. And they're neighbors. They eat together. They hang out together. They build their farms together. So they were working on these things at the same time. And if they needed wood or they needed planting materials or soil or whatever, they would just call the particular store and say, hey, order on Lawrence account, we'll come pick it up. And Mr. Dickinson would either pay with his American Express or pay with cash, whatever was necessary. One of the things she said was that there's nothing linking these receipts to his farm, and that actually is not true. Although they do say Mr. Rangel's name on the top, if you look at the bottom of the hydroponic receipt, it actually has a note that lists the address of the property. Now, you can't see it because your slide is too small, so I do have a copy of that in larger form, and if you allow me just to pass it around, this is actually the application received from planning. She sent it to me, and it's stamped with the date and everything. This is not something that we made up last night. May we approach? So what you'll see is a receipt from Murphy's Hydroponics for some garden materials and supplies. And while it does say Mr. Rangel's name on the top of the receipt, simply because of the contractor account issue, what you'll also see at the bottom of the receipt, it says notes, and it says 2385 Wagner Road. So, if we go into the actual ordinance, what does the ordinance say about those receipts? The ordinance says, date stamped receipts for equipment and supplies in types and quantities commensurate with commercial cannabis cultivation in the area proposed to be cultivated. It doesn't say there you have to have the applicant's name stamped on the top of it. It doesn't say there that the registrant has to be connected. All it says is it has to be date stamped, which it is. It has to refer to medical cannabis cultivation, which it does. And that it has some connection to the area to be cultivated, which on the very bottom of the receipt, it says it right there. It says the address. There's no more connection you need to that property than the address. So, looking at that receipt, while it does say Mr. Rangel's name, and we've explained why that is, it's only because they were working on these things together, and they would call down to the store and say, hey, put it on Lawrence's account, we'll come pick it up. When they get there, the store was keen enough to ask them, where's this going? And they put the address down. So we disagree that this particular receipt is not connected to the property in question. and it's sufficient as per the ordinance to show that those supplies were used on the property. So that's reason one for the denial that we disagree with. And we also, just so you know, in your appeal packet, we have pictures of that particular equipment on the site. Now, the pictures were taken after the deadline, obviously, because we didn't know this was going to come up. But we took the pictures to show that's what the stuff is. The second thing, the second point we want to address is, and you can turn to page 7, is the sufficiency of the evidence in regards to the photographs. And we admit that the applicant, he attached the same photographs on both applications, and there's an easy explanation why. When he originally went to apply and register his operation, he was going to do it as one operation. There is no dividing fence or anything between the properties. It's all his. When he got to the planning department, they told him, hey, you have to split this up. It's parcel by parcel. So when he did that, he just erroneously attached the same photographs. Those photographs, the timestamp photographs, they are of the same hoop houses or whatever it may be. But I want to draw your attention to one thing. Inadvertently, in a sense, he actually attached a photograph that shows the grading prior to May 10th. If you look on your slide number 7, which it's a picture, and it's actually stamped, received June 20th, but it's a picture from the application that you have that you're passing around. It's the picture, it's his actual plot map that he drew. But that plot map actually shows the grading, the initial grading of the cultivation space. So while it's not timestamped, it is a photograph of the cultivation area, and it shows the initial tier of the grading. We actually went, and it's right, he has a drawing there, he shows the garden, and it's right on the edge of those trees, you can see the grading. If you go to slide 8 in your packet, we took a Google Earth image of just recent, I think it's the same one that she showed, and you can see that same grading area with plants planted on it. So it's the very same area, it was attached to the application. The only thing we're missing is a timestamp. The question then is, well, when was that picture taken? How can we corroborate or verify when that picture was taken? Well, we would ask that we're able to submit supplemental information to show that. And if you look at slide 9, as part of our Planning Commission appeal, we submitted that information that showed the very same tier graded with plants in it, and those are dated. There's 2 pictures of the initial grading on March 6th, and then it shows plants in the ground in April. So we know that if these were taken March 6th and April, I believe 19th, that the Google Earth image had to be prior to March 6th. So that appears to be sufficient to show that that operation was actually occurring. And I want to step back a little bit, just talk about the ordinance itself. The ordinance, from my understanding, is that you guys made that ordinance to protect the residents of the county who had these particular operations in existence. Mr. Dickinson is one of those people. He's had that property for 3 years. He didn't just come in last week. And he's trying to do everything he can to comply with the ordinance. Specifically, looking at the application, the first two points are the receipts. I think we have a pretty good case that those receipts show the connection to the property. And the second is a photograph of the cultivation operation. And it had that. It wasn't time-stamped, and we admit that, but we asked for a little leniency and allow us to put supplemental information that showed what that time would be. The last point is a little bit more complex, I guess I'd say. If you go to page 10, there appeared to be an issue with the square footage of the cultivation area. And this is where we don't really have a full explanation as to why this happened. On his application, it does say 16,335 square feet. However, as I told you, he originally wanted to do one application for the whole thing. He split it up into 2. his original number was somewhere in the 6,000 to 8,000 range, I believe. What happened was when he went to turn it in, the clerk informed him that you should put the maximum amount of square footage allowable by your property. If you look at the picture on your slide number 10, it's a picture of the actual application, and you can see where the clerk whited out his number, wrote in the number herself, and initialed it. So he, in good faith, believed that he was getting advice from the planning department on what you should do, how you should proceed. If we had the electronics, it would be color, and you can see it's different handwriting, it's a different color. It's actually, you can tell it's whited out because you can see the elements of the original number above it, and the clerk actually initialed it. We don't know why she did that, or we don't know what exactly that was to show, but it clearly shows now that it was her advice that he was following, even in her own handwriting, as to what number should be. He doesn't dispute at this point what measurements the county has taken since that time, and his understanding now is it should have been the area that it was at the time. That wasn't the advice he was given, and he believed the advice in good faith. He didn't allow her to do that in some nefarious way to try to get a bigger area than he was allowed. He believed what she said. He believed that it was the right way to do it. And this is actually, it's part of the packet that you have up there, and it's part of the application. You can see it. They have a colored copy in the planning department that shows that he didn't put that number down. So looking back on the denial, there's 3 reasons for the denial. I think we have a pretty good case on all 3, that there should be some supplementary information here. It seems one of the issues that we have is that if we go back to the receipts, the reason for the denial of the receipts is not something that's listed in the ordinance. There's nothing in this ordinance that says you have to have the name of the person on top of the receipt or the name of the person all over the receipt or anything like that. It says you have to have a connection. You have to show it's for commercial cannabis supplies and whatever it may be. And that's exactly what it shows. To deny it or to have that as a reason for denial is a violation of due process in the strictest sense, simply because it's an arbitrary denial. There's no way, there's no criteria listed that we can say, okay, well, this is what it should be like this. You should have this name or that name. It's nothing. It's a totally different category of denial. If it had said, hey, there's no address, or this is not for cannabis, this is for, this is a wheelbarrow for something else, that's a different story. That's not what the denial was for that particular point. So the same in terms of the pictures, while we agree that there's no timestamp on that picture shows the cultivation. Mr. Dickinson was doing all he could to comply or substantially comply with the ordinance as written, as far as he understood it. Maybe he got some bad advice or didn't fully understand what the department clerks were telling him. But we don't feel he should be punished for that. And just with the acceptance of the supplementary information, it shows everything that he puts on the application. It shows it in plain sight. He's got the right pictures, he's got the timestamps, he's got everything, and we submitted that to the Planning Commission, and they refused to look at it. In terms of the square footage, as you can see, you'll see on the application, he was taking the advice of the Planning Department. Why should he be punished if that's the advice whoever was working there doled out? Why should he be punished for taking it? It would seem if he was to say, I'm not going to do that, I'll do something else, it would be more cause for denial. Because he'd say, oh, well, they told me to do this, I did something different, and it was just plain wrong. He followed their advice. So in terms of the square footage, he's willing to accept what the county's measurements are. There's no issue with that. That specifically addresses the application. And our argument here is that the application, as submitted, is sufficient. Everything is there. It may require a little bit further inspection. It may require a magnifying glass for some very small print, but everything is there. In addition, we did, if you go to page 12 of your packet, we did give a little bit more context to some of the receipts that we added at the Planning Commission. We showed the fence. It's a shared fence. Darcy talked about the receipts were submitted on, same receipts submitted at the Planning Commission were on the other parcel. Well, that's because the fence that they built, and you'll see it in the picture on the right of your packet on page 12, the fence surrounds the entire property. There's a road, Liberty Hill Road runs on the backside of the property. The fence goes from the 2385 parcel all the way around to, I believe it's Wagner Road on the front, all the way around the whole property. So both parcels are using those supplies, and as you guys know, it's a requirement that you have a fence or something to shield the cultivation operation from public view. And that's exactly what he did. That's why the fence is there. Prior to this stuff, there's no reason to have a fence. We also included, and in the appeal packet, there's a litany of receipts and different things and pictures, but we just wanted to highlight some of them. One of the things he did, he repaired the groundwater well. On the application itself, it says they're going to use groundwater to water the plants and provide irrigation, and he invested some money into repairing that ground well. In addition, he also bought a large, I think it was a 1,100 gallon tank to hold the water, to water the plants. That tank was bought in February of 2016. We just wanted to show the receipt that corresponds to the picture, and show you the picture of the tank that's on the property. And just for context, this tank actually sits right next to the residence, which is on this particular parcel. Slide 15 is simply more of the garden supplies. There's receipts attached to our appeal letter. Those particular receipts correspond to these particular supplies in use on that garden in that space. We have the potted bags, we have the drip lines, different cages and things they use to actually build the garden. So in conclusion, we ask for this particular remedy. We ask that the Board of Supervisors take a closer look at the application itself and allow a minor amount of supplemental information to give greater context to what exactly was meant on the application. And we ask that you that you grant his appeal, and that you approve his registration. In the event that you can't make that decision based on supplemental information, we ask that you remand this back to the Planning Commission and direct them to look at all the information as stated in the ordinance that speaks of their appeal power. Mr. Dickinson's here today, and we're willing to answer any questions that you may have.
Okay. Mr. Dickinson, would you like to make further comments on your case?
What was that?
Would you like to make further comments?
I just would like to say that, like you said, I've been here for 3 years. I didn't come to do this. I like this place. I like the people here, and it's a good place. This was an opportunity for me. I take care of my grandfather with Alzheimer's for like the last 10 years, so this really this is an opportunity for me to do stuff, because that's actually what he does for his Alzheimer's and stuff, and it helps him. But I just want to say that I appreciate you guys taking this into consideration, and that's about it.
Okay. Thank you. Presentations by members of the public. Any presentations by members of the public? So we have a rebuttal from the public participation there, I guess. So you have that opportunity for any more rebuttal against the appeal, or for the appeal.
No, I'm good.
Okay. So we got staff summation and rebuttal.
I just have a few things I'd like to sort of touch on based upon the information that was provided. The plot map that was shown on, let's see here, I numbered my pages. Number 8, Mr. Stanley stated that you can see some grading. I'm taking a look at the two photos side by side, the Google Earth image and the plot map, based upon where the house is located. I will agree it's kind of hard to tell in the photos, but I'm not seeing the extent of grading that's showed in the June 26th Google aerial image as opposed to what's shown on the plot map Google aerial image. So, and there's no date, so it's hard to tell if this is a 2014 plot plan image from Google Earth, but I'm not seeing that grading that's shown on there that you can see on the one side by side. You know, receipts aside, the applicant registered for a mixed light operation. There isn't any evidence that was submitted in the application that shows that they had a mixed light operation on that particular piece of property. The photographs that were submitted were unfortunately submitted for the adjacent site. Photographs were not provided by that June 30th date for the actual project site that we're looking at. So there's, again, going back to that deadline, is they were required to submit that evidence by June 30th. The photographs that you see before you today that they've submitted as part of their supplemental information, sure, there's plants that are in pots. There's photographs that aren't date stamped. I don't know when those photographs were taken. I can go back to the information that staff had based upon the June 10th aerial imagery that we had that did not show proof that there was that extensive amount of cultivation occurring on the site, as opposed to what you now see in that August-September aerial imagery, which shows some cultivation on the site. When those plants were put in, I can't tell you, but I can only estimate sometime between June and August from what I can see on those images. Furthermore, there seems to be, in fact, I'm a little confused in terms of square footage of what they're asking for. Mr. Stanley stated that originally when the applicant came in, he was going to do one application, split it into two, that the original number was 6,000 to 8,000. It was whited out. Now it shows 16,000, but they're willing to accept 10,000. So I'm not sure exactly what's being cultivated, what was originally cultivated on the site, or what the site was prepped for in terms of grading. I cannot speak to in terms of the whiting out and what was the original number on there. What I can tell you from the over 700 applications that we took in, there were many times that I sat at a table in Department 1 and I asked registrants, you've put down 22,000 square feet, is that what you're cultivating, or is that what you want to do? And a lot of times we did ask for permission. Okay, if you're only truly prepped and cultivating for 10,000, we're going to white it out and we're going to change it. So I can't speak to what that original number was on the application. It clearly does say that it's now 16,000 and it was whited out. But what that number was underneath, I don't know. I don't know if it was 10,500 and I don't know if it was 6,000 to 8,000. But it sounds like from the conversation we just heard that it might have been 6,000 to 8,000, but he's willing to consider 10,500. So maybe some clarification on that would be appropriate. The only other thing is I would like some clarification on the fencing. It would appear from the photographs that there is fencing only in certain areas, but the ordinance does require that your entire cultivation site be fenced and secured. So I'm not sure if this site currently, if the board were to grant the appeal and allow the registration to move forward, if that site is fully secured. And just in closing, in terms of staff, is that the Planning Commission did make it very clear that the evidence that was presented to them after that June 30th date was not evidence that was submitted by the deadline, and therefore they were not going to consider any supplemental information that was provided by the appellant, and their decision was based upon what was submitted in the registration packet that met the June 30th deadline.
Okay. Any questions? staff. They get a chance to answer the question.
Can I address those points?
When we get to it.
Yes, sir.
Mr. Chair, I have a question. Are the original photographs available in the file that we can take a look at? We have a black and white copy here. Item number 2, in reference to the clerk who whited out the square footage and put the initials, is that clerk present? Is that you?
That is not myself.
I'm sorry, what's that?
That is not me.
Is that clerk present?
Not in this room, but is here at the county.
Okay. She or he is available for talking to?
We could certainly grab her. Yes. Can you grab the original file, the 224? 224, I don't have that one.
And, Mr. Chair, I do have questions of Mr. Dickinson, but I'll reserve that until after
Yeah, I
comments.
just want to get all the questions out, anything to staff, so that we have a full spectrum of, answers.
Well, I have a couple of questions, mostly to county council.
Those are the images that were submitted in the application.
Correct. What's being passed right now are the images that were submitted with the original application. I pulled those from the Planning Commission staff report, which is attached to your packet.
Were those digital photos? Do you know?
No, they were a hard copy photo that we
Hard copy,
then scanned
made from
in.
digital photos or negative photos?
Probably because it has that's how they get the time date stamp that's on there.
So probably digital or negative?
Probably digital, and then they printed them out.
All right, thank you.
If I may address, I do have a copy of the application on the computer here, which you can see. So they don't show whether we have it in color.
So, as far as the question on the due process and what the planning commission can hear or receive as far as new evidence goes, can you clarify that for me a little bit more?
Under section 1790.070, which is the procedures for appeals, it indicates that, it does indicate that all relevant and noted facts must be presented to the planning department staff and the planning commission. All of that evidence was presented to the planning commission, and it's my understanding that they can hear it and they can take it under submission and apply it as they feel appropriate and necessary. It's my understanding that their basis was because it did not meet the deadline within the urgency ordinance, wherein that the urgency ordinance specifically says that a complete application needs to be submitted pursuant to this chapter by June 30th. So, for purposes of an appeal, I guess the Planning Commission can receive and consider any evidence before them.
And then so that, I'm just talking out so I can understand it better. So basically, if I'm hearing you correctly, they submitted all of this evidence, or almost all of this evidence, at the Planning Commission level. Then the Planning Commission said, well, you didn't submit it by the deadline according to the urgency ordinance, therefore, we're not going to consider that evidence because the ordinance says that you had to have it in before. Is that correct?
Because they did not meet the deadline in the urgency ordinance.
Right. And so if we, as a board, said, well, we'd like you to consider that evidence, could we do that?
Certainly.
Send it back, like you suggested, move it back to the planning commission, say, look, we think you made a mistake here, we want you to look at this evidence that you didn't look at.
Certainly, if there's new and compelling evidence that you feel the Planning Commission did not consider and would like the Planning Commission commission to consider, you can remand it back to the planning commission for another or new hearing. My understanding is that that information was presented to them, and they found that although this additional evidence was presented, it still did not meet the requirement under the urgency ordinance to provide a complete application as of June 30th.
And we cannot consider that because the planning commission made that decision?
I'm sorry?
We can't consider that evidence because the planning commission did not?
You can consider any evidence in front of you that was presented to the planning commission.
Even if they said that?
Yes.
Okay. Thank you.
Now, did I hear, before you take off with that later, that there's another parcel under the same applicant, and some of these receipts were used in their proof?
Correct.
Applying.
What we found was one of the receipts, and without going through the files, but there was one that was also submitted as a receipt on the adjacent parcel, which Mr. Dickinson has a registration application for. I think the explanation we received was that he purchased supplies for both properties, under one receipt.
So why would the receipts even be an issue on this one, I guess would be my...
So in this particular one, initially the receipts that were submitted were not enough to tie it to this particular property. Subsequent to that, supplemental information that has been received could tie those purchases to this particular property. But the Planning Commission stated that that was information that was submitted after the June 30th deadline, and therefore it wasn't information they were going to consider.
Okay, thank you.
Mm-hmm.
Any other questions?
Mr. Chair, one question. Question of counsel. You mentioned that you had provided some receipts after. Can you identify that in the presentation? What
So it wasn't in the presentation.
It wasn't? Okay.
We're talking to staff, our staff right now, only. And then we will get to them, okay?
Mr. Chairman, there was a request that the staff person that had taken in the application be present to answer any questions that she might have about remembering the occurrence. Unfortunately, she's not in the office right now. I don't know where she is. She may be at lunch.
Okay, thank you for trying, Mr. Moore.
Yeah. I do have the files. Someone requested to look at the original photographs.
I would like to see the original photos. Thank you, sir. Anybody else like to see on the board? Thank you.
Okay, Supervisor Oliver, are you finished with your questions to staff?
I am.
So if you'd like to go ahead and question the comment, that'd be good.
Okay, counsel?
Yes, sir.
I recall you mentioned receipts that you have submitted. And once again, repeat my question. Those receipts after the Planning Commission hearing are not contained in your presentation pack. Is that correct?
No, they're pretty voluminous, so I didn't want to give you guys a 60-page presentation. With the original appeal letter, we attached a number of exhibits, and we had receipts and pictures, more than what's in the presentation. We just pulled out selected ones so that you could see that they tie in.
So would it be safe to assume that the receipts contained in your presentation were submitted with the original application?
Yes. Well, no. One of them was application, the receipt that you have there was submitted originally on the other parcel for the wood.
Could you identify that for me, please?
Excuse me?
Could you identify that?
So, at the planning commission level, we submitted additional receipts. One of those receipts was the receipt for the lumber that she mentioned was on both of the applications. So, those receipts are included in the appeal, but they were not a part of the original application for this parcel.
Is that the receipts from Lowell? Do you know as identified in your presentation?
The receipts from Rangel, Lawrence Rangel, that's, those are, or from Lowe's.
I'm looking at receipts, and I don't have page numbers, unfortunately. Investment in the grow operation facility tank purchase. There's a receipt there.
Yes.
Was that presented with the original packet?
No. So we had, so I can back up and give you a better view. We had 3 submissions, in essence. We had the original application, which had the 2 receipts that had Mr. Rangel's name on it, and they're actually stamped in your packet, received. We had a second submission that was in response to the denial that gave more information addressing those issues, and that was the second submission. The third submission was we just full bore gave you guys everything that we had so that you had it. And so as part of the third submission, the Planning Commission receipts were included as well as an exhibit to the appeal to the Board of Supervisors.
Thank you, Counsel. Chair, I have a question for Mr. Dixon.
Okay.
Mr. Dixon, thank you for coming. And is it Dixon or?
Dickinson?
Dickinson, I'm sorry. The receipt referenced in the presentation packet provided by your counsel indicates, and excuse me, I'm getting a little old, can't see the last page too. Apparently it's some type of material delivered by dump truck, and it has the name of Lawrence on the customer. Could you explain the relationship between Lawrence and whether or not that was signed for by Lawrence or by you? Or
No, it wasn't. I just picked it up. It wasn't signed for by Lawrence, but as far as Lawrence goes, he's my neighbor up there. He just moved up there about a year ago. I've been there for about 3 years, so he's doing the same thing, and we got material. I got material for him. He got material for me, picking it up. So, and that's how we did it, because obviously we're trying to build it and get material and everything, and we had that deadline, so we were in a hurry to try to get it done.
What is Lawrence's last name?
Rangel is his last name, yeah.
Okay. Did Mr. Lawrence have an established account with this vendor?
Yes.
Were you authorized to sign on that account?
He authorizes over the phone. I just picked it up.
You just drove the truck?
Yeah, yep.
Okay. All right. Do you have any financial agreement with Mr. Lawrence about any cultivation activity?
No, he's just my neighbor.
Properties, or?
No.
You're just friends?
Yep, he's just my neighbor, actually.
And this material was for your particular operation, correct?
It was, yes.
Did you use all of it for this particular parcel?
Yes, the lumber, there was a receipt of lumber that was used for the fence. So that fence does span both properties. In the picture, you can see the shadow from the fence, how it goes across.
I'm talking about the receipt from Murphy's.
Hydroponics? Yeah, that was for that property, 2385, yes.
And that wasn't for lumber, though, was it?
No, it wasn't.
What was that for?
I believe it was drip lines. There could have been soil. I mean, we bought a lot of stuff, cages, all kinds of stuff. Tubing.
That was solely for your property?
Yes.
Your operation?
Yes.
Not Lawrence's?
That's right, yes.
Okay, thank you.
Any other questions?
No, that's fine. Thank you, Chair.
Any other questions from the board?
Can I ask staff a question? Okay, now the ordinance is going, the ordinance states that you have to have a completed application in by June 30th. It's rhetorical, correct?
Correct.
Okay, if they had their application in, but there were inconsistencies that were responded to when staff met with them, would you consider that they had their application in and it was completed? When was the whiteout done on this, I guess, is one of the things.
I'm going to assume that was done at the intake of the registration application.
Before June 30th?
Correct.
So are you willing to assume they had a completed application in by June 30th?
I would state that they had an application in by June 30th, but we were not doing completeness checks when we took them in. We were ensuring that they had receipts, they had photographs, they had deeds or whatever else they needed, but we were not doing a full verification process at check-in.
I'm a little confused on why we would deny the second property with the receipts being a consideration and not the first property.
I can't answer that question. I did not process the denial of this. But for one reason or another, this application was brought forward for review. And at the time, the planner looked at it and determined that the receipts were not accurate for this site, that there was no cultivation, and that the square footage didn't match.
With regard to the receipts, when we reviewed it first, it appeared that the receipts all applied to the adjacent property. And that's why we rejected this one, denied this application, because we could not tie the cultivation activity that they claimed was happening on the property and the investment that was made in that property to that property based on the information we had that was submitted prior to June 30th. So that was the reason for denial. Peter Maurer, for the record, for Planning Department.
So, when you deal with other applications for like subdivisions or other permits, and somebody comes in, submits their permit, and it's not complete, which happens often, I would imagine.
Mm-hmm.
Is there a timeline that you need to complete the application?
The normal process for a development proposal is we have 30 days to review the application for completeness. If it's incomplete, we notify the applicant, and they have whatever time they need to make it complete. There is I think they have 120 days to respond. If they don't, we consider the application abandoned. This is a different situation in that, this is identifying sort of after the fact. This was an urgency ordinance that was adopted. The board's our understanding, the intent of the board in adopting that was they were to freeze things, what was occurring on May 10th. And so we're trying to look at what documentation could they provide that predated the May 10th decision to allow whatever people had invested in to continue their operation and not allow new cultivation to occur until we had a permanent ordinance in place. And so when the applicants, and not just this applicant, but all the applicants submitted their application, we had to base our decisions on what they had provided to us in their best effort to demonstrate that they were indeed cultivating on that piece of property. They had made an investment, and we used whatever resources we had available to make that determination. So it's a little different situation when you're sort of looking at something that is going to occur in the future as compared to the things that occurred prior to May 10th.
So if you go into the planning department and you complete an application for any other project, you have this 30-day window to complete. You turn in your application. The planning department says, well, you didn't submit photos, or you didn't submit the right deed, or whatever it is. And you send back a letter to the applicant saying, this is incomplete, but you stop the time on it, right, as far as the amount of time that you need to process the permit in, correct?
Yes, but there's no deadline for submission. The ordinance had a clear deadline. You must submit the application information by June 30th.
But what I'm getting at is the process that normally works is like, I'm going to do this, here's my paperwork, and you say, no, your paperwork's incomplete, we need stuff back from you.
Right.
And you need to do it within a certain amount of time.
That's correct.
And so now we've decided that we're going to not do that. Like how we treat all the other permits that we do, we're going to do something different. And so if you have not submitted all of your paperwork correctly, by the time the 30th of June rolls around, you're out of luck, is what we're saying. And that doesn't seem to be a fair process to me, because you have to take it out of the fact that it's cannabis and marijuana, and you have to take it as any other project, because that's what this is. It's a project that we're looking at. And so you need to have the applicant, the property owner, who is fully intending to apply by our laws that we've set up, applies, and the fact that they're not completely done with their permit or they've forgotten something goes contrary to everything else we've always done. And to not then, at the planning commission level, where you have the opportunity to bring and appeal that decision to say, well, you already have failed because the 30th has already passed. So you've set up an appeal process that is impossible to win.
Well,
right? I mean, because there's no, like, if you didn't turn that information in by the 30th.
Well, the registration process is unique to all the other, different than all the other processes we have in the department. No other, the urgency ordinance established a deadline to submit the information. No other application process we have has a deadline that is required to submit. And so that's what we're basing our action on, was the information that was submitted by the applicant by that deadline date.
And that makes a lot of sense for the planning department, and I understand that. But what I'm saying is that there needs to be a chance for the applicant to say, no, wait, we have that information, we just didn't put the right, photo in there. And there's no chance for them to do that because the planning department, the planning commission is not allowing any submittals after June 30th. So there's no real appeal process that's going on right now because you guys have rightfully so decided that June 30th is what the urgency ordinance is. That's it.
Right.
So I don't see how there's an appeals process at all for this, for that particular part of the thing, because you have the applicant, property owner doesn't have the chance to say, no, we're actually complete. We just, that fell out of the file, or that, whatever circumstance it was, they can't then defend themselves. There's no process to do that. Is there?
I think that the appeal process, if they can demonstrate that the information they provided did show they were cultivating.
Right.
But it's the submittal of new information that we and the planning commission have struggled with.
Right, and that's the crux, right? The new information, like if you forgot to submit something or you didn't submit something, that's it. There's no appeal to say, well, wait, we have that information, we just didn't put it in the packet. I don't see how that's...
I guess it's incumbent upon the applicant to make sure they submitted everything that they needed to demonstrate that
right,
was
but
there.
Any other process that we have is not set up like that. Why
That's right.
is it not set up like that? Because it's not a fair process, right? If you have an incomplete application, you come in and you're denied because it's incomplete, and you appeal it to the planning commission, they say, no, we'd do nothing in this county if that was the process we used.
Well, and like I said, the process is different because there was a deadline for submittal. There is no deadline for submittal on any other application
But
type.
how do you get around that point if there's actually information that proves their application is indeed completed by June 30th, they just didn't have that one piece of evidence? That seems like to me the point where the planning commission exists and say, oh yeah, you're right, that should be submitted. But the planning commission, as far as I can tell, is just saying, no, June 30th is the deadline. And we are not accepting any other evidence to come in past June 30th if it wasn't in the application. That's what they're saying, right?
That's correct. That's what they're saying.
So how is it an appeals process? Go ahead.
The appeal process is laid out for all applications for Title 17. The urgency ordinance is specific to the urgency ordinance, and the board put it into place on May 10th. Everyone, all applicants, all registrants knew when the board adopted the urgency ordinance that there was a deadline to have a complete application submitted by June 30th. So there was, in fact, a time period between May 10th and June 30th wherein there was a potential time for, had they come in earlier, for staff to review it and correct it before June 30th. Unfortunately, because everyone waited until the last week, staff did not have time to vet applications for completeness prior to that June 30th date. But ultimately, the burden is on the registrant, on the applicant to meet these requirements.
And to be fair, this wasn't submitted, and this was one of the earlier registrations, but we simply did not have time to review any of these because we were so overwhelmed by the response to submittals.
Right, and so to me, it seems like we should have a place that the Planning Commission accepts that evidence because there was no time, there was no time for, like you just submitted, there was no time for that to be worked out.
Certainly the board has the ability, if you feel that the evidence presented today is significant, you have the ability to remand it back to the Planning Commission to consider it with direction that if an application was submitted by the June 30th deadline, that the Planning Commission and planning staff can review and consider additional or new supplementary evidence to meet the requirements of the urgency ordinance that was not submitted with the application. That is something that the board has the authority to do. If you feel that the evidence presented is significant and you feel that the Planning Commission should consider that prior to making a decision.
I think it's important because otherwise we're going to hear it's going to be the same thing over and over again.
I just want to remind the board that this is more than just the receipts. This is also about the first prong of the test, which is under A or B. If you recall, applicants have to meet or provide evidence under 1795165N3. They have to either meet A or B and one of the other prongs of the test. So the other issue is whether there was date-stamped photographic evidence of grading and or earth moving commensurate with the area proposed to be cultivated. So, or date-stamped photograph evidence of cultivation commensurate with the area proposed to be cultivated. If you recall, the board, the purpose of this requirement was so we would register grows that were there, not allow for expansion of grows or new grows. So somebody who had a 10,000 square foot grow couldn't expand it to a larger square footage. If you recall, that was in the record when we adopted the urgency ordinance.
Yeah, and just to be clear, I'm not as concerned about the specifics of this one case here. What I'm concerned is that the Planning Commission is not even hearing or is not allowing the submission of additional evidence because of the June 30th deadline. And that puts us, I think, in a bind up here and where we could resolve this issue in a more fair and equitable way at the Planning Commission level if we directed them to look at new evidence that came in after June 30th. Because that's what I think appeal process is for, is to give the applicant a chance to say, no, look, we really were doing this. Because right now we're like, no, you weren't doing it. Sorry. And so it just seems like the Planning Commission should be taking a look at it without that arbitrary, it's not an arbitrary deadline. It makes sense. But now that they're hearing the appeal, it also makes sense to get to the truth of the matter. Were they doing these things before the deadline that we set? Right? Not did they submit all the right paperwork. And so I think the Planning Commission should look at that. That's what I would like the board to direct them to do. What do you think, Cliff?
I think that we have an ordinance that we opened up applications from between May 10th and June 30th. And people came in to do that. There was a lot of people that delayed their action. And there were some people that didn't. Some people jumped right on it. They were prepared. They were ready. It wasn't like it was a brand new thing happening. So I think that we need to stick to our ordinance and the rules of the game.
And you don't think the planning commission should even take a look at that evidence?
I think the evidence, the application is between June or May 10th and June 30th is the application provided.
I have a question. You know, part of this application process, and I don't want to get too far off on this particular application we have before us, but part of the application process is that we also had the extension until September 7th for more application justifications to be submitted, or?
There were 4 specific items that we knew would not be available by June 30th. So we provided until September 7th, and they were the seller's permit from the Board of Equalization, the county business license, the registration with the Secretary of State if you're a corporation or a business entity, and submittal of the notice of intent and a receipt from that or some documentation from the water board that they had filed the appropriate paperwork with that. Those are the only 4 items that were allowed to be submitted after that, and we're sort of facing some of the same issues with applicants that did not meet that deadline as well.
Okay. And then did this applicant pay the fee?
Yes.
Okay. So, Chris, I understand where you're coming from. Because it is a new process and there's a lot of information, a lot of clarification, a lot of, information that needs to go into these kinds of decisions. But it was created as an urgency ordinance to kind of put a break on, whether you want to call it the land rush or not. And we had to start with something. And we knew that something was not going to be the perfect scenario. So, I stand behind the urgency ordinance and the deadlines that we establish. I totally understand where you're coming from, because I think it's a cumbersome process and it's a cumbersome application. And there's still rules to be defined as we move forward. And so I'm hopeful that with the permanent ordinance, a lot of these kinds of things can be fleshed out, be more specific, and be able to better define those rules. But in this case, it was defined as the urgency ordinance to have something in place, because prior to that, we had nothing in place, and it was really willy-nilly at that point. So understand what you're saying, support with what you're saying, and I think those ideas can be pursued as we look at the permanent ordinance down the line. So for this, I want a clarification that this was a deadline issue of June 30th, having the proper documentation in place. It was found that the documentation wasn't proper. And so the Planning Commission didn't look at anything besides the June 30th date. So what was on June 30th? I understand the applicant had 2 parcels. Some confusion perhaps about how to register the 2 parcels. But, I look at that as part of the registrant needing to totally understand, seek advice, whether it's from an attorney, whether it's from, the alliance or whatever it might be, to help sort through this application process, to understand it and to do it correctly.
All right, so are we finished asking staff questions? May I have a rebuttal by members of the public? Anybody in the public wish to talk about this?
Michael Falvey, Mountain Ranch. I'm sure everybody in this room, everybody on the board, everybody here has faced deadlines in their life, drop-dead deadlines. And looking for excuses to ignore said deadlines is not a good argument to me. Supervisor Pawnee touched on it. You know, there's deadlines that we all have to adhere to. Thank you.
Any other public comments?
Al Segal, Taxpayer Association. I think we concur with Chris. This process is supposed to be regulatory, not suppressive. If the purpose of this ordinance is to suppress marijuana cultivation by putting tripwires to encourage failure in the process, then we've turned government upside down. We're doing something wrong. We're violating property rights. Constitution doesn't permit that. So we have to go back to fundamentals. If we find that there was an error in the application which was corrected, in this case, and in all cases similar, you need to go by the truth. The truth is the spirit of the law is more important than the letter of the law. I don't know how you can do other than that.
Any other public comments? All right, so I'm going to close the appeal hearing at this point. What?
I wonder if there was an opportunity for us to remark on the questions that staff had and some issues we're discussing here in relation to the process itself.
You know, I went through that process, and there wasn't any comments at the time. So I'll go ahead and let you do that.
I just want to start with, as Mr. Wright said, you know, this is it's a due process issue. It's one of the foundational elements of our country is due process. Before you deprive anybody of life, liberty, or property, or use of property in this way, you have to have due process of law. If you have an appeal procedure in which no information can be submitted, you don't have an appeal. And that's one of the issues, is that we agree with it, is deadline's May 10th. Well, if we have information that shows prior to May 10th that these things were happening, how do we not have an opportunity to present it on an appeal basis? You know, everything in this country that we do, you have an opportunity to appeal. Everything. This is the one process where hard deadline is done. We've all had deadline, that's true. But every deadline, you have an appeal. And that appeal, you're allowed to give information, you're allowed to have reconsideration. You would have no Supreme Court, you'd have none of that if everything was a strict deadline. It doesn't work that way. That's all we're asking. We're asking to review the evidence that we have. If you need more pictures from before May 10th, we have pictures from before May 10th. The issue here is not, for us, is not that we don't have the evidence. It was simply that when we submitted it, there were some clerical errors on the application, and before we even knew about the errors, we had no opportunity to submit any more information. So the appeal is basically a rubber stamp of whatever the planning director decided, because there's no more evidence you can present. And that in and of itself is unjust and unfair. And it appears that we should be able to at least have the discussion and at least have the evidence reviewed to say, hey, if the pictures were, well, all of your pictures are after June 30th, so you're out. Fine, that's no problem. But if we have pictures from April 15th, those pictures should be at least reviewed to at least try to corroborate or verify the information. Specifically, you know, the information that we submitted to the Planning Commission was specific to the denial. And it appeared they were requesting more information. But if they weren't, what was the point of the appeal? Because they said you have these issues with your application, address them. Well, we addressed them, and it said, well, we can't take any more information. Well, in what circumstance would an appeal ever be granted? The other thing is, you talk about the urgency ordinance, and you guys did hard work getting that done, and we appreciate it. But one of the things is you have to look at the law itself. There's no provision in that ordinance that abates the appeal procedure. And you don't lay out a separate appeal procedure that says, only for this ordinance we're going to have this separate process, and you understand what this process is at the outset. Our understanding is that we go by the same appeal process that every other decision is in this county in terms of planning commission. It's laid out. It says, you are to present all this evidence and bring it all to our attention. But it appears that you're creating another process without any ordinance or anything that actually says that that's what you're supposed to do. It doesn't say in your emergency ordinance that no information will be allowed after this date. It just says you have to have your application in. What if you misspell your name? Too bad, so sad. You don't have any opportunity to correct it. It's just not the way things are supposed to be done. If we would be more comfortable with that, with the tenor of this argument, if the ordinance said the appeal procedures laid out in section, I think it's 17, council? 17, those appeal, that's abated for this process. But it doesn't say that. And that would give you the indication that, okay, there's no appeal here. Or the appeal procedures that you know and you've used before, they don't apply. So you better get everything, I's dotted, T's crossed, everything perfect, because you don't have an opportunity to correct it. Some of the issues brought up by staff, we do have information that we can give you to show the fence surrounds the entire property. But we wouldn't know you needed that until you gave us an opportunity, until you told us that you needed it. So even if we had information right now to address that issue, we have an opportunity to present it. If there are clarifying things that need to be done, there's no opportunity for us to give any information to do that if you're not going to accept supplementary information after June 30th. And in addition, staff brought up some additional causes for denial that were not listed on the original appeal in terms of the mixed light, things of that nature. That wasn't listed on the original denial. And I don't believe that you can, in the course of the appeal, bring up new reasons for denial that we have no opportunity to address. And even, the planning director admitted, well, even if they did get it on the first day, we wouldn't have the application process to tell you you had a problem so that you could resubmit it by the June 30th deadline. So what are we to do? Mr. Dickinson has substantially complied. He is trying his best to get everything in. He's not a land grabber who came in here in May and is trying to start something up real quick. He's been here for 3 years. Owns the property in fee simple. He's paid all the fees, all the taxes, everything you've asked him to do. And all he's asking you for is opportunity to correct some clerical errors. That's it. Some minor things that the evidence is right there. If you look at all the evidence, there's no way you deny it. It's all right there. Thank you.
Sharon, I would like to address some of the issues that were brought up by council, specifically about due process and the appeal process. I want to make sure that the board is clear, and we've had discussions in prior appeals about this, is that this is a de novo hearing, so the board has to consider any evidence presented to it independently from what the planning commission did. You don't give deference to the planning commission or the planning commission's decision. You have to weigh the evidence in front of the board independently. And so that is the reason why the appeal process is set up the way that it is, where all evidence is to be presented to the planning commission at the appeal hearing, because then any that is the evidence that the board is to consider. we've had prior discussions about new evidence that was not presented at the Planning Commission hearing or the Planning Department. In that situation, that is when the board would remand it back to the Planning Commission. In this situation, all of the evidence that was presented to the Planning Commission is in the record and is evidence that the board can consider when making its ruling and determining whether the evidence presented to you meets all of the standards and whether you want to approve or deny the appeal. So there isn't a due process issue because ultimately the board has all of the evidence that was in front of the Planning Commission, and you would, regardless of what the Planning Commission did or said, you have to weigh that evidence independently from the Planning Commission. So I just want to make sure that the board is aware that you are to weigh all evidence in front of you and determine whether you want to approve or deny this appeal. The issue about remanding it back to the Planning Commission, if you feel that all of this evidence is significant and you feel that direction to the Planning Commission to consider and weigh all of it and direct them not just for this appeal, for all future appeals to consider any evidence presented to them, as long as they met the submission of an application by the June 30th deadline, that is certainly within your prerogative. But again, for purposes of today's hearing, all of the evidence is in the record. The board has the ability to weigh all of the evidence that was presented to the Planning Commission and come to a conclusion independent from the Planning Commission.
Okay, so I am going to now close the appeal hearing and we'll bring it back to the board for discussion. Appeal hearing is closed. Or discussion.
To me, this is a message of what we're saying to our Planning Commission and how to review these going forward. It's a controversial code at best. Some people in the county are not happy with it. Some are happy with it. But we owe it to the 700 applicants to interpret it rigidly, and we owe it to the people who do not like this to interpret it rigidly. The appeal, I could maybe approve an appeal if I felt the Planning Commission had made mistakes on their judgment. I don't feel that they've made mistakes on their judgment. We have deadlines. This is not the same as other applications that might come through, and I believe we need to stick with them.
Any other comments?
I'm good.
Debbie?
No.
Chris? Okay, I have just one comment. I don't believe the regulation is excessive. I believe that the county gave an opportunity for people to sign up on a specific time period between May 10th and June 30th. And it was made very clear that they must follow the ordinance and the application. At the bottom of the first page of the application, it says, applicant or landowner is applicable shall notify Planning Department in writing within 72 hours of any change to the information described above. And I know that for many people, the urgency ordinance may have been confusing to them, right? But it is in place, and it's something that it was board action, and I feel that we need to follow it because hopefully we can get to a point where we move on with this process and get to a final ordinance eventually. But right now, it is the urgency ordinance. And so I know also that there were other applicants that filed on time. They got their information in on time, and they were complete. And so, as nice as Mr. Dickerson is, I think he's an honorable guy. it's unfortunate that he didn't, in my opinion, have all the information needed to be able to qualify for this. So that's how I feel about it right now. So can I have a motion, please?
I move to uphold the Planning Commission's denial of 2016-1081 Dickinson Commercial Cannabis Registration Appeal.
I'll second.
So I have a motion by Supervisor Kearney.
Chair,
Yes.
for the record, I just want to clarify. I want to clarify for the record that you have reviewed and considered all of the evidence presented to you in today's hearing that has been presented through the Planning Department, Planning Commission, and in front of the board today.
Very thoroughly.
Yes.
That was pretty obvious today. So.
Just wanted to clarify for the record.
All right. And so I have a motion by Supervisor Kearney, a second by Supervisor Ponte. All in favor?
Aye.
Aye. Opposed?
Yeah.
Thank you for your presentation.
Chair, do you want to take a 5-minute break to allow?
Yeah, let's take a 10-minute break. How's that? How about this? How about we go to lunch? It's 12 o'clock, and so let's be back at 1 o'clock, okay? All right, so welcome back to our Board of Supervisors meeting, and we're going to start off with item number 16.
16 is from the Environmental Management Agency. Authorize the board chair to execute a professional services agreement between Calaveras County and Tetra Tech Incorporated for the recovery of homeowners' insurance revenue associated with the Cal Recycle right of entry debris removal operations for an amount not to exceed $854,656.81.
Good afternoon, Board of Supervisors. Mary Rose Ruchikanga with the Administrative Office. I'm actually here also representing Environmental Health as Jason Bateser is in Sacramento this afternoon. Before you is the last piece of our debris removal Butte Fire program funded through our public assistance projects. This is the insurance recovery piece of that project. If you recall, we entered into contract with Cal Recycle for Butte Fire-affected properties for debris removal. The state has required us to implement a insurance cost recovery program to recover the cost of that debris removal. So this contract does exactly that. It is going to be doing the public outreach, the insurance policy review, determination of policy limits, et cetera, and working with homeowners in recouping at all insurance monies owed to the state for that debris removal program. This contract was let through a request for proposal in July. We received 2 bids. Tetra Tech was the successful bidder as per our evaluation committee. We then started contract negotiations and finalized about the end of September with the contract negotiations, and we are bringing forth the contract in the amount of $854,656.81.
Any public comments on this?
Board, good afternoon. I'm Michael Farley. This is Bob Ellenberg from the company called Unity Adjusters of California. We are here to express our comments because of some glaring deficiencies which exist, or we believe exist, in the bid tendered by Tetra Tech. Before we get into the merits of what we view to be the discrepancies, I want to be very clear about one thing. Just in the few hours I've been sitting in this well and listening, it is abundantly clear that Tetra Tech has been an enormous asset to this county following the fire in September 2015. Tetra Tech's own website amply demonstrates how qualified those folks are to render what I'll describe in general terms as construction or construction management related services. But what we're talking about in connection with this RFP has really very little to do with construction management services, or really anything that Tetra Tech historically finds within its sphere of experience. Bob Ellenberg is one of the principals, Victor Romero is one of the principals, and Peter Romero is the other principal of Unity Adjusters of California. I'll just refer to it as Unity. They have been public adjusters for decades. Their sole professional purpose is to provide adjustment-related services to those folks who have a homeowner's first-party insurance loss. That experience, that decades worth of experience, comes from tedious, sometimes mind-numbing review of homeowners insurance policies. Now, I'll be honest. When I sat down and I read Tetra Tech's bid and I compared it to Unity's bid, I'll be the first to admit, Tetra Tech's bid reads more smooth. It just reads very well. I mean, you can just glance right through the first 30 pages. There are about 3 pages that have a chart and some columns. But then you look at Unity's bid, and it's a grind. It's even got samples of what were provided in the bid, sample documents of summary of losses. The purpose of the summary was not to demonstrate line item by line item what sort of evaluation goes into determining debris removal, but rather to demonstrate how complicated the whole process is. As a general rule, it's been my experience that people are of the understanding, when they're told by their adjuster, oh, you get 5% of your coverage for your debris removal. And everyone thinks, okay. But no one really understands what that means. Tetra Tech's bid may not necessarily include the specificity of these summary loss documents, but likewise, it doesn't even acknowledge that there is a difference between Unity's bid to recover more indemnity dollars, meaning money owed to the policyholder. Rather, their bid seems to suggest what's called subrogation rights are in play, which is to say, if PG&E is at fault for the fire, well, Tetra Tech will go after PG&E to recover the funds somehow that PG&E owes. Now, as we stand here in this boardroom, the difference between indemnity and subrogation may be meaningless, and it may be legalese lost in the ether. But out in the real world, when the adjuster is on the phone with the public adjuster and there's a dispute concerning how much is to be paid, that difference can be in the tens of thousands of dollars. Again, I'm not here to diminish from what Tetra Tech can and has done. I just heard this morning that they're principally involved right now in tree removal, and there was a supplement to a contract. Again, we're not here to diminish from what they can do. But Tetra Tech's bid is silent as to one very important item, and that is their representation that they have licensure issued by the Department of Insurance to act as a public adjuster. Based upon our research, we believe that deficiency, that shortcoming, amounts to an outright bar to an award of this contract to Tetra Tech. Why? Not because they can't get one in the future, they can't get public licensure in the future, but rather because they didn't have a public adjuster. Yes, sir.
Sorry, I was advised to let them proceed with their comments.
Really?
Yes.
Have I talked too much?
Is that why you're giving this to me? All right. Proceed.
Am I going on too long? Anyways, I'll be brief. The fact that Tetra Tech is prominent in their field does not make them qualified without a license to serve as a public adjuster relative to collecting first-party benefits on behalf of the individual homeowners here in Calaveras County. I'd be happy to take any questions concerning those opinions.
So are you appealing or protesting? Protesting.
We are protesting, yes, sir. I might add that our protest was in part deficient because as of the time we were required to file our protest, we didn't really have an opportunity to even examine Tetra Tech's bid. So when we finally got our hands on it, we did our best to scour its terms, scour its conditions. In fact, when we learned that the board had awarded this RFP to Tetra Tech, the first thought that came to my mind was seeing how involved Tetra Tech is in this county, that the board may have thought that, you know, they could hit the ground running. I mean, they're an enormous company. They're here already. And what's in the best interest of the residents of this county is Tetra Tech. And then I remembered reading in the bid that they don't have any office space set up here and expected the county to fund the office space. Unity's bid, from the very beginning, anticipated the need to open up office space, open up halls so that the residents could come in, have one-on-one, face-to-face meetings with licensed adjusters, in particular public adjusters. So our protest, in all honesty, may have been deficient, but in self-defense, that wasn't because we were deficient, we just didn't have it to look at.
I have a question for County Council. Okay. What is the process here? I mean, they just got up and started talking, so we weren't, I mean, you guys were, didn't look like the board was aware of what was going on.
Honestly, my question was, who are you and who exactly are you representing?
What's happening?
Yeah. Well, again, I'm Michael Farley, and I'm representing the other bidder.
Yeah, first, let me see.
Okay,
the
so
County Council can
hang on a second.
Very well.
Because what was presented to us is our agenda item.
Yeah.
Right? I just got a note now. It says it's RFP protest. This is the first I heard of it. Anybody else hear anything like this? No.
That's my assumption.
So
that's my assumption. The item in front of the board is the contract. The bid was put out. There were, as staff indicated, there were 2 responsive bidders. The item before the board right now is to award the contract to the winning bidder. It appears that these 2 gentlemen are the representatives of the other bidder, who is not the winning company. And so, based on the testimony that they presented during public comment, I assume that it was the protest. Would you like to clarify, Mary Rose?
Thanks.
I'll just speak briefly to the protest process of an RFP. Once a successful bidder is deemed successful of an RFP, we then begin contract negotiations. Once contract negotiations have finalized and we have set a board date, we then notify the unsuccessful bidder 18 days prior to that board date of our intent to award a contract to the other bidder. So that letter was sent to Unity Adjustments that our intent to award the contract to Tetra Tech. In that letter, it specified that they had 7 days to respond to my letter in regards to soliciting a protest of the RFP. They did respond and sent me a protest letter within that 7-day period. I then spoke with the evaluation committee, I spoke with council and responded to their protest letter and advised them that if they still wish to protest the RFP, that they had the ability to do so here at the board meeting. So that is they're exercising their right within protest to come and speak before the board.
except for the board didn't know anything about it.
The board, when we agendized this item, it was well before the notification of the protest that was coming from them.
Well, I mean, still, we could have had some kind of communication even as late as Thursday last week.
And I acknowledge that Supervisor Oliver, Supervisor Edson, I had no idea that they were coming to the board to protest to the supervisors.
All right, so we have to follow in my mind, we have to follow the agenda item.
Mm-hmm.
That's what's on our agenda.
And
I let them continue further because, further than 3 minutes, because I was asked to by county council.
Mm-hmm.
But normally it's a 3-minute period. So if that's a protest, I think we should follow a process around it. I don't know, what is the process then?
I don't know how a protest differs from an appeal mechanism. I'm sure that they are probably different. But as our county code, that's kind of the process that we do. Just as our previous with Phillips and Jordan, they kind of came and petitioned to the board. The board has the ability to take heed what they say or to award the contract to Tetra Tech. I will state that the evaluation committee did a thorough job of evaluating the proposals brought forth. We took our time in writing the RFP proposal, in extending the proposal deadline to address the numerous questions received by Unity Adjustments during the proposal period. And then we took time in thoroughly evaluating those proposals as well. The evaluation committee was made up of Mel Knight, our director, our consultant, brought on from CAHA, the California Environmental Health Association, that's overseeing the debris removal program. Rebecca Callan was also part of the evaluation committee, as was Judy Hawkins, our director of risk management and insurance. And so out of those 3 employees, they reviewed the proposals within I would say at least 3 within a time frame during the day, and came to the decision of awarding the contract to Tetra Tech. That was done because of the experience that Tetra Tech has of dealing with federal and state agencies, the scope of work that they brought forth in ensuring that the dialogue between the state agencies and the county was going to be done to the utmost fullest, and also the capacity of Tetra Tech. They have the staff and the capacity to begin work immediately once the contract is fully executed. And I think that was some discussion amongst the evaluation committee as when I spoke with the protest letter with the evaluation committee. For those reasons, that is why the evaluation committee awarded the contract to Tetra Tech.
I'm not disputing that. What was the day that you knew? What was the date that you got the protest back from them?
Well, it was actually, I sent them the original letter on October 5th that we were awarding the contract to Tetra Tech. And then I didn't hear anything back, and I realized that their letter back to me was stuck in our spam email. And so I didn't notice until, believe October 15th or 16th. However, their letter was done within the 7 days. When I noticed the timestamp, it was on October, 10th that they sent it. So it was well within that time frame. And so then I met with council, we responded, and then that was where it was left. I had no notification from them that they were going to protest up to the Board of Supervisors.
But they did protest.
Mm-hmm. They did submit a letter of protest, which is, we've had occurrences like that before as well with requests for proposals.
Do we have a process in place that we follow and for protests?
Yes. We, once so it has to be done specifically within a time frame. Once a protest letter is received, we review the letter with the evaluation committee to look at what they are protesting, and then we respond to that letter.
And then what happens?
And then they have the ability, if they so choose, to make their concerns at the Board of Supervisors.
During public comment period?
During public comment period.
Did we send them a response?
I did, sir. I sent them a response on October, I'm sorry, I don't have that with me. I believe it was the 17th or so.
Okay.
stating our intent to still award the contract to Tetra Tech.
You might want to put in a process to notify the Board of Supervisors in the future, so we're not, like when you notify them, maybe you notify the board.
Staff report?
Sure. Yeah, but the staff report was already submitted to and approved prior to.
Right.
Yeah.
So just have send the county council, we could send that to us or something like that, like some type of, so we know what's going on.
Or alternatively, the department is bringing the item forward.
Right, not to put any burden on the county council, so.
Yeah.
Somebody.
Okay.
Thank you.
Duly noted.
Okay.
Any other questions?
Thank you.
Make an approach in the interest. If I can speak to just a couple of things that she said. The normal protest procedure for government bid contracts, everywhere I've ever seen, it's written in the state of California's ordinances. It's written in many, many places, and your counsel can probably confirm this, would normally be that the bids get opened publicly so that if you didn't get the award and you see something in that bid that makes you think that's not right, I want to protest, you're given that. That was not the procedure that was followed here. I searched your ordinances. There may be written somewhere, and I missed it. She says you have a procedure in place. I could not find it. I read through all of your ordinances in an effort to find out what your protest procedure was. So in essence, I was told I have to protest it, but I don't know what I'm protesting. I was relatively certain that Tetra Tech didn't have the license that are required by the state. I got an opinion letter from the Department of Insurance saying you must have this license. That was the main thrust of my protest that I did give without being privy to seeing their bid. And as to why the selection committee would have ignored that, I don't know. Federal law under which you're getting this grant says that any license that are required must be, and they must be at the time that the bid's done. So I don't know why they felt that they could just do that. As to why we didn't notify you, when I got the letter on the 17th, it said that if we wanted to protest, we could protest to the board. So we showed up today. That's kind of the way the instructions looked to us.
I'm not disputing any of that.
Thank you, sir.
I'm just, we're just trying to make sure that the process is correct, and make sure that you're getting your due process too. We're just a little bit surprised, I think, that this is here because we knew nothing about it.
I understand.
And if I might add, our principal concern, in as much as these folks have dedicated their professional lives to public adjusting work, is to ensure that the residents of Calaveras County maximize their recovery under each individual homeowner's policy relative to debris removal. Our concern, or in particular the concern of Unity Adjusters, is midway through this process, a process that Tetra Tech anticipates will take up to 6 months. The Department of Insurance could very well issue a cease and desist order stopping future work because there's no licensed public adjuster at Tetra Tech to serve the individual policyholder. And I would direct your attention to Insurance Code Section 15007 and 15008. The insurance code is what mandates the public licensure requirement. Not the industry, not custom and practice, it's the legislature.
Okay. Would you like to say anything else?
Not this time.
The one other comment, I could go through their bid and give you many examples of why I don't believe that they're qualified, but they did say they would do this in 6 months. You can't tell how much money is in left for debris removal in an open claim that hasn't been paid out the policy basic limits on the basic coverages. A lot of these will go 2 years. The Department of Insurance rules have that these folks have up to 2 years to settle these claims. It is an impossibility to close correctly and collect all the money for the debris removal on a claim that remains open that has money within the basic coverages. That won't happen on many of these claims till after 6 months. Tetra Tech doesn't even know that. They said, we'll be done in 6 months.
If I could highlight, just put that in a simple meaning. Under your general garden variety homeowners policy, when you have a loss, a first-party loss, the carrier and the state law allows each homeowner up to 2 full years from the date of loss to make, for instance, a personal property claim. I unfortunately knew some folks who lost their house. And I assure you they're not worried about going down to the local hobby store and replace the golf clubs or whatever other fun things they had in the garage. They're focusing on their structure, getting the kids back in the house, getting them back into school, getting back to a routine. Additionally, the reason Bob is suggesting that Tetra Tech's estimate of 6 months is unrealistic is because in addition to providing 2 years, the policies also require a homeowner who is making a demand for personal property prove that they've replaced it. So everyone who's collected personal property over the course of 15 years has 2 years to replace everything and give proof of purchase to the carrier in order to get reimbursement or direct indemnity from the carrier. From my personal experience, I know for a fact the folks that I know down here are not going to get everything replaced in 2 years, let alone 6 months. But that's the way the policies are written. And that's why Tetra Tech's bid seems to suggest a lack of knowledge, a lack of specialty knowledge, expertise, relative to the recovery of all the indemnity due and owing under a homeowner's policy. Thank you.
Hi, Sarah DK, Deputy County Counsel. I just wanted to make one small point about having an opportunity to review the other bids or bid in this case, or that being open. It's a procedure by which an RFP goes out, bids are solicited, they're reviewed by the panel, and then state case law in the state of California is very clear that once terms of a proposed contract have been negotiated with the winning bidder as determined by the panel, at that point and not before, that's when the other bids and the scoring sheets become public upon request to other bidders. At that point, but not before, so as to not prejudice the contract negotiations, but at that point prior to today, so that non-winning bidders do have the opportunity to review those prior to coming in at a meeting like today.
I have a question for you.
Yes.
Do we have somewhere in our county code the process?
The process for RFPs, for protests, I am not sure.
Supervisor Wright, there isn't anything in our county code that addresses a procedure for it. Typically, it is laid out in the actual RFP.
The procedure is that, folks can make a written protest should they so choose, which in this case did happen, and then obviously, as always, have the opportunity to come to a board meeting and make their pitch.
Okay, thank you.
Okay. So, does Tetra Tech want to say anything? All right, so I'm assuming that by our RFP that is being presented to us, that all of the laws that are applicable to the insurance, because the insurance codes are being considered by the selection team, right?
Yes, sir.
Okay. Anybody else have any questions? No?
No, not at this time.
Okay. Public comments, please. No public comments?
In response to the last answer that she gave you, I have a letter from the Department of Insurance saying these licenses are required. So I don't know how they can make that response, and I'd be happy to provide that. I brought that letter today, and I'd be happy to provide it to the board.
Any other public comments? All right, bring it back to the board.
I guess I would need some clarification. I don't know if it comes from council or the committee, but was there a review of the specific licensures needed for this kind of work, for this kind of contract?
Because we don't want to not get reimbursed for this, we actually sent the RFP and the proposed contract to Cal OES for review for FEMA. This isn't an individual adjuster contract. This is not a representation of the homeowners. That is not the point of this RFP or the point of this contract. It is to identify if there's insurance, and it's really a representation of Cal Recycle. That's who this, and FEMA. So this whole contract and the whole RFP, the whole point of it is to prevent duplication of benefits, which is a requirement under public assistance. So if a homeowner received funds through their insurance or has availability in their insurance for debris removal, then FEMA wants it. And in essence, they will, Cal Recycle will receive that, and then they will give it to FEMA. That's the whole point of this. While I can appreciate the gentleman's response on wanting to be there for people who have lost their homes, or they might have the ability to work with those individual homeowners to get more benefit out of that insurance, that is not the point of this contract. That wasn't the point of the RFP, and that is not something that we're going to be paying for.
So was the RFP, clarify for me if I heard it right, the RFP was reviewed by FEMA, OES?
Yes.
And then afterwards, did FEMA and OES review the specific?
We, when Mary Rose told me that she had gotten the protest, we went ahead and sent it to Cal OES, the proposed contract to Cal OES to make sure. They looked at the RFP, they looked at both of the responses, and they looked at the draft language of the contract. Their concern was the same concern that the reviewing committee had, which is that the other bidders' focus was really on adjustment, and that was not the scope of the work. So it was, he's correct. When you read the two responses, they're very, very different. And I think, we couldn't quite understand why there was so much of a night and day difference, but the reality is the one respondent in terms of scope, which followed the requirements set forth in the debris removal program and the duplication of benefit rules, was Tetra Tech, and that's why we chose Tetra Tech.
And this evaluation process you went through is now public?
Yes.
Much like the others have been, so anybody can review them and...
Yes, and they were notified of the evaluation score sheets and all the documentation.
Okay. And who was on the committee again?
Mel Knight, who's our debris consultant, Rebecca Callan, and Judy Hawkins, our Director of Risk Management and Insurance.
Okay. Thank you.
And, fortunately, unfortunately, since Lake County got to go through this too, we kind of compare notes in terms of, what did their RFPs look like? What did their contracts look like? What, how did they, get respondents back on any of the bidding? So we aren't having to necessarily reinvent the wheel. And if we have concerns or issues, we can also deal with that. And Mel Knight was really kind of instrumental in helping us figure out how to go forward with this. He has been involved in debris removal programs before. So
the protest is claiming, like licensure deficiencies in dealing with this. Have we checked those?
that would be if you were doing adjustments, and we're not doing adjustments. This is not adjustments. This is not adjuster.
Well, forgive me, this is way out of the normal wheelhouse of what we're looking at.
Yes, and that's why we had to let it out for contract, because the state was going to require the county, and we just do not have expertise in this type of, arena. Hence the RFP and the contract. But yes, this is not an adjustment scope of work. This is the go-between between recouping the monies to go back to the state. And that was the two differences in the proposals that were given to us. And that is why the licensure is not required.
May I respond? It is a critical observation.
Go ahead.
Question, Chair. Sir, I'm just a little confused on your standing in this. Are you counsel?
I am counsel. I am counsel for
You're
Unity
attorney
Justice.
of record for
Unity Justice, correct.
Okay, thank you very much.
Very well. Let's be very clear about the fundamental aspect of this RFP. No homeowners insurance, no homeowners insurance owner, homeowner, policyholder, no RFP. No homeowners insurance policy, no debris removal. The board needs to understand that there is no, I can't say it's impossible, because maybe in Calaveras County, everyone who suffered a catastrophic loss in September 2015 will recover, repurchase, and present proof of purchase of all their lost personal property within 2 years, within 6 months. I doubt that's going to happen. What that means is, pursuant to the terms of the written insurance policy and nowhere else, money will come from whichever carrier owes indemnity. So the question is, well, how much? Each homeowner will provide a different answer. If one homeowner, just by way of an example, one homeowner has $300,000 to repair their structure and $200,000 of indemnity for personal property recovery. If a carrier submits a proposal to restore the burned down home for $250,000, and within that $250,000 is $25,000 worth of debris removal, one might think, well, that's the debris removal right there, $25,000, which is not correct. The debris removal is calculated at 5% of all the coverage. Coverage A for the structure, coverage B for personal property, coverage C for exterior appurtenances, fences, detached garages. It isn't just coverage A. So then the question becomes, well, what if the homeowner and the carrier can't reach an agreement on the cost to restore the building or the home pre-fire? Is it going to be $300,000? Is it going to be $310,000? That directly affects the amount of indemnity owed. Because if the cost to restore the home, put it back to the pre-fire condition, is just $300,000, the total debris removal fee or indemnity is 5% of $300,000. But if it takes less than the full limits to restore that residence, the 5% applies to the additional indemnity not consumed by the structure reconstruction. Same as to the personal property. Same as to the appurtenances. In other words, and it's a little surprising to hear that the RFP doesn't really relate directly to the adjustment of a homeowner's insurance claim when without the insurance, there is no debris removal. I don't doubt the sincerity of everyone here trying to get these people on with their lives. But what's required is a degree of expertise that guys like, where'd he go? Oh, here.
I will say something again in a minute.
You know, guys like a public adjuster who dedicate their lives to know about. Again, I'm not here to diminish from Tetra Tech and the enormous job they've undertaken, but if any one of you on the board has had to deal with your own insurance company, whether it's a broken windshield or somebody broke into your house or you've had a house fire, you've experienced the pressure the carrier brings to bear. Every insurance company, like a publicly traded corporation, answers to shareholders. They're not going to throw out money left and right. They're going to do their best to adjust the claim downward in order to reserve their indemnity, to keep claims low. Public adjusters are licensed like no one else. Not an insurance agent, not even an adjuster who works for an insurance company, but a public adjuster who's licensed under the insurance code. And the RFP doesn't exist if everyone in Calaveras County is uninsured. It exists because they are insured.
So he's giving you a sampling of how complex he knows this is. I want to go back to the licensing issue and the examining and contacting the state. First of all, whoever has this contract can't just go get the money from the insurance companies. You have a contract with your property owners. It's called a right of entry permit. They have a contract with their insurance company to indemnify them, to pay them for that debris removal. They are in the middle. In the very first place, every single homeowner's policy says that company will only deal with that homeowner on that claim. You need to get permission to deal directly with the company. I addressed that in my RFP. I have a form that I have designed, said we should have the folks in Calaveras County sign it. If they want you to deal directly with their insurance company, sign the form and give them permission. Otherwise, the insurance company doesn't have the approval to do it. Let's go to the license issue. I did not think a license would be required, but I'm a very exacting person. That's the reason I can do this so well. So I looked at the code, insurance code. I contacted the Department of Insurance. They directed me to the department that makes these kind of decisions. I discussed it. He said, send this to me in writing. The public adjusting code specifically says a person who, he's got it with him, in any way acts to affect the claim. I sent them your RFP. I didn't just call them. I sent them, this is what the code says. This is the RFP from this county. And their response, and the reason I didn't think a license would be needed, an employee doesn't need it. And I thought, well, it's going to be a contractor, it's going to be the same way. It says, according to the facts provided, that was your RFP, we believe your proposal to act as a contractor does not make you and your government employees to use the exemption of licensure in CIC 150088. The exemption only applies to government employees performing their duties, while in this concept you would not be. We suggest you and the employees apply for an interim public adjuster's license, which would allow you to quickly get licensed under your supervision and be able to assist in performing these tasks. They wrote that letter based on the RFP, not me calling them on the phone and saying, hey, do we need a license? I know this stuff inside and out. I have been involved in this before on the other side of the table, and I can tell you that the people who have collected the money for FEMA leave hundreds of thousands, if not millions of dollars on the table because they don't understand the complexities of how the debris removal works. And you are obligated by the agreement that you have with the grant, with FEMA, to collect every dime of money that you're entitled to. I would challenge you to get Tetra Tech to show you examples of how they will go about this, what kind of documentation they'll get, what kind of questions they'll ask, and I'll show you mine, and you can be the judge of which one is thorough and which one will get all the money.
I might add that there is also an additional legal requirement that I had to do some research on myself, and the statute, actually, the Code of Federal Regulation, it's in the 500 series, not only obligates the county to recover all available indemnity, all reasonable efforts to recover available indemnity, there's actually an obligation to verify those efforts. The verification is a statement made under penalty of perjury that you've done so. So it's not simply a matter of they don't have the expertise. It's a matter of whether this county board will be prepared to verify that everyone has exercised their sound discretion and awarded this contract to a company unlicensed to perform the services called for by your RFP. That verification is, at least in my judgment as the attorney, that's the kicker. Because you sign something under penalty of perjury, now you've introduced some serious weight into the issue. What did you do? How did you verify? And here we are telling you the company has license to do the work. That's not what we're doing.
Yeah. And as far as your staff is concerned, I know they did an excellent job for what they know. They don't know what they don't know. This is a very complicated situation. I get frustrated in trying to communicate it to people. It's far more complex than it appears. Thank you.
Thank you.
Any further?
Thanks.
Hey everybody, Will McGowan, Project Manager for Tetra Tech. So actually I just want to come up and make a statement. I've lived here in Calaveras for 8 months out of this year doing the Butte Fire recovery work, and I managed the team to put together the database that was submitted to CalRecycle as a product. That product, CalRecycle approved. Now, you can talk about not understanding the debris removal process and understanding these properties. Can't say that because I went through almost every one of the 860 packets personally that debris removal was performed on. I've spoken to a good percentage of the property owners as it relates to their right of entry, including notifying them of us coming to the property for debris removal, including us putting together all the backup and supporting documentation for the reimbursement through CalRecycle for this contract, and working with Mel throughout that project to help make sure it ran efficiently, and any means for the local residents and things that they were requiring was agreed to. So with that product, CalRecycle is also, we've done the work in Erskine down there in Kern County, and also in the Clayton Fire right now in Lake County. So we continue to do work with CalRecycle because of how much they appreciate our product. Now, you can go on our website and you can look, and you may not see anything in relate to the scope of this project. But with the scope of, as it relates to the scope of this contract, we've done 1,600 homes for Bastrop, Texas, from the wildfires out there. We've done 600 homes in Galveston for the flood recovery. We've done numerous HMGP along with CDBG projects that relates to this same scope of work. So you can go to our website and you can look, but you're not going to see the quals that's also stated in our proposal to you. This proposal, obviously, this RFP was put before Cal OES and CalRecycle, along with your staff has verified that it has been thoroughly reviewed. So I just want to say that we have a full understanding of what this program consists of, and we are more than qualified to meet the needs. Talking about office space, we've worked with CalRecycle and the D-Rock here in San Andreas, and we also are currently working in the office next door. We are fine with acquiring our own office space. We can hit the ground running immediately. So that's not an issue whatsoever. So I really don't want to get into all of it. It's just I think there's some statements made. This contract is not this contract is not a public adjuster contract. This contract it is not that. And you know, I just want to say I appreciate your time and thank you very much.
Question. So the RFP itself, because I already know how OES and FEMA works, was sent to them for to verify that it qualifies.
Yes, it was. Rebecca Callan submitted the RFP to Cal OES for review and approval, along with the proposed contract as well, and the bid proposals and all the evaluation sheets.
Okay. Thank you.
Good.
Any other questions?
Okay, thank you very much.
All right, bring it back to the board. I'm looking for a motion on the item.
Well, in review of this, it looks as though it was vetted, reviewed by FEMA, OES. They look at the RFP, the scope of work. They've looked at the contractor. I see things in here that, the selected consultant shall be or shall subcontract with various disciplines to effectively deliver the project. I think that is an opportunity as you get into this, if you find where you need those more special or various disciplines, has the ability to do so. I can appreciate maybe the differences of when you're looking at insurance. It can be very complicated. And as I see this over and over again, it is specifically looking at the debris removal and things related to that. And I would think that through that process of recovery and trying to recruit from the insurance, that they'll be looking at those kinds of things, pockets of money, as you might say, to make sure that we're maximizing the reimbursement that is entitled to this specific project. So I'm most comfortable and would be willing to make a motion if there's no further discussion or questions from the board.
Okay. Go ahead and make your motion.
I authorize the board chair to execute a professional services agreement between Calaveras County and Tetra Tech for the recovery of homeowner insurance revenue associated with the Cal Recycle right of entry debris removal operations for the amount not to exceed $854,000 or $854,656.81.
All right, can I have a second, please?
I second.
All right, so I have a motion by Supervisor Ponte, a second by Supervisor Kearney. All in favor?
Aye.
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 Opposed? Thank you.
Item 17 is from the Board of Supervisors to appoint applicants to serve on various committees, commissions, advisory boards, and county service areas. This item was tabled at the last meeting to ascertain if the applicant for the Central Sierra Economic Development District was available to meet during the day. I have reached out to the applicant and I have not heard back from him, so I'm requesting that this item be withdrawn until I can speak with him and put it on a future agenda.
Okay.
You need a motion for that?
Need a motion? Okay. Nope.
I agree.
I agree also.
Yeah, it's fine with me.
Okay, so can we go to then the consent agenda?
So can I just ask something for the consent?
Sure.
Item 7 on the agenda lists the minutes of the Board of Supervisors meeting on October 11th under public comment. We had a hiccup and I didn't catch that when we printed the agenda. So the minutes should be part of the consent agenda.
Okay. Okay, so let's move on to consent agenda. Consent agenda items are expected to be routine and non-controversial. They will be acted upon by the board at one time without discussion. Any board member, staff member, or interested party may request removal of an item from the consent agenda for later discussion, and that would, and then we're going to include number 7, minutes of Board of Supervisors regular meeting into the consent agenda.
Thank you.
Any members of the public wish to pull a consent agenda item? Okay. Any members of the board wish to pull a consent agenda item?
I'll make a motion to approve the consent agenda with item number 7 being added.
All right.
Second.
So I have a motion by Supervisor Ponte to approve the consent agenda with item number 7 included. And I have a second by Supervisor Wright. All in favor?
Aye.
Opposed? All right. So we're on to supervisor announcements. And we'd like to go first.
Attended a special COG meeting last week. I also attended a State of Jefferson meeting, which was quite interesting. And yesterday had a solid waste task force meeting. That's all I want to report since our last meeting.
All right.
Going back, I know that we did report out our special board meeting. I did attend Volunteer of the Year award ceremonies. That was very happy to say it was received and issued, awarded to Mr. Pete Paddleton from Arnold for his outstanding work for volunteer work in the community. Thank the organization for allowing me to present that. I did attend a demonstration of a digital laser scanning system presented to the Sheriff's Department. That item was actually discussed in the budget, and that decision rests now with the Sheriff's Department as to the comparison of both systems. Attended the LAPCO meeting on the 17th. Attended the Treasury Oversight Committee meeting on the 20th. Yesterday, I did attend a meeting regarding a constituent issue at the Avery transfer station regarding security measures on fencing. I did meet with the Forest Service also to discuss a program that's in its very early stages right now, and until I can verify information and get some information back, I'll be able to relate more details on that, but it does actually deals with tree mortality. And I attended the Central Sierra Child Support Committee meeting yesterday in Sonora. And that's all I did. Except
I too attended the child support meeting, and the agency continues to do well. For last year, they exceeded their budget in regards to collections, and their numbers remain at their designated approved budget levels and beyond. I attended the EMS meeting earlier this month in Copperopolis, and basically approved a number of air ambulance contracts at that particular meeting. So. Angels Camp had a part of a COG project, review of their sidewalk system, you might say. They had a public meeting. It was pretty well attended overall. You walked different aspects of Angels Camp in regards to sidewalks, and it ended with a meeting in that evening for more public input, and they plan to have a few more meetings related to that. So, that's all I have.
All right. I always like those meetings where you get the planners and transportation planners and land use planners out there walking around with the citizens, trying to figure out how to plan your town. It's a really good idea. I attended the first 5 commission meeting and all the jobs training agency board meeting. It's the first time the new director was there, so executive director. He's a real go-getter, so hopefully he'll be able to move that agency up to the next level, especially with public profile and letting people know about it, because there's still a lot of folks who are out of work and could use some support in getting back into the workforce. I also would like to make a request. The Common Ground item, I'd like to bring that back for next Tuesday, or the next meeting.
Oh, yes, absolutely. Thank you.
You actually have to take a poll on that, right?
No, I can request since I was absent. According to our policy. Cool. Yeah.
Great. All right.
Unless there's 4 people who don't want to reconsider it, then I'll.
Okay. Anybody else? You've done all yours already?
Yes. Yeah.
Okay. So on the 17th, I went to Calaveras. Met with Calaveras and FEMA. I went with Director Krovitz and Earl, who works in Public Works, in order to kind of straighten out what's happening with the tree removal up in the burn area, and learned quite a bit. So we came back on the next day and did the emergency resolution, which give it the emergency situation. I think that they need to be able to put this into a project workplace, and so I plan on going again up there on Thursday at 9:30 a.m. and see if we can't get, we're going to try to get them to act as quick as possible, because I'm really concerned about the standing trees. and the situation in regards to the weather that's coming, the weather that's here, and the cold nights, the hot days, and the wind and rain and anything else that affects these trees that are standing and dead. And we need to get them out immediately. So Thursday, I'm hoping to find out something. And on the 21st, I also attended the Sadie Jefferson meeting just to find out what's going on with that. It was a pretty interesting meeting. On 22nd, which was Saturday, had Wines on the Main here in San Andreas, which is sponsored by the Calaveras County Chamber, and that was a pretty fun event. Some of the Calaveras Has Talent winners were there to sing, and this young lady, Romy Evans, if you ever get a chance to hear her sing, it would be worth traveling for. She's pretty awesome. At the same time, Harvest Festival was happening in Valley Springs, put on by the Valley Springs Parents Teachers Association or organization, and it was a first annual event, and it was full of young kids and young parents, and it was a blast. I was greeted at the door by Dorothy from The Wizard of Oz. That was a lot of fun. And that's a pretty darn good event for the first time in that area. Seems like that the Parent Teachers Association down there can put on an event, and automatically it turns out to be something really good. So great things happening. And that's about all I have for now.
Chair, I see we have a special meeting on November 15th. What's on the agenda for that meeting?
That is correct. Actually, that we were hoping to bring before the board before that date, but that's when the Sheriff's Office will be available to review the Emergency Operations Plan, or the EOP, and then also they're going to be bringing a PowerPoint presentation forward to discuss the future of the Office of Emergency Services, our local program.
So if you remember, over a month ago, the Sheriff was supposed to bring at the end of October the OES discussion, and so basically we're going to have it all in one day so that it makes sense that way. And I guess the Sheriff had the EOP scheduled on this agenda, and I felt that we should probably spend some time on that. I didn't know how today was going to turn out, because it seemed like it was going to be a really full day, and that is going to be something that's probably going to involve a lot of discussion. So I felt that it would be a great idea to be able to bring that, the OES, and what else is on that too?
That's it. EOP and OES.
Okay. So
at the last meeting, we postponed a presentation or an idea that Public Works is going to bring forward.
Yeah,
Are we going to discuss it at that special meeting as well?
Yeah, so that's the third one. Director Krovitz has a emergency management presentation that he would like to bring.
And when would the board like to have that brought forward?
Same day.
Same day.
Already now. If you want my answer.
Okay.
Well, really?
Yeah. Good.
And,
Only 2 o'clock.
So it just
with the Shirley Brown Act.
he actually had that agendized before, and then held it off because OES thing, and so now it's all fine.
It makes sense.
I will let Mr. Krovitz know about that item for the 15th.
Okay. All right. Anything else from the board?
Yes.
All right. So we're going to adjourn into closed session.
Wait. I need to ask for clarification on an item. Item 5 on the agenda was the proclamations for the American Legion's Boys and Girls State. We tabled it, I think that we said to the next meeting, but I'm wondering if you want to...
Do it on the 15th?
No, if you want to do it at the night meeting of November 29th, when their parents may be able to attend as well.
I'm good with it.
All right, I'll leave it up to Steve.
You can do it on the night meeting.
I will not be in attendance on the night meeting. I'll be on county business outside of the city and county.
Yeah, it depends, I may or may not be around.
So do you want to do it at the, we can do it at the next meeting. I just thought I would throw that out there as an alternative.
We may not have to have a night meeting.
Yeah, let's do it on the 15th, Steve.
Why don't we do it? We can do it on the 8th. That's the next meeting.
I can attend that.
All right, 8.
Let's do it on the next meeting.
Okay,
I put them
thank
on
you.
already, so.
Thank you for the clarification.
You're welcome.
All right.
Thanks for bringing it up.
So let's adjourn into closed session.
Still want to know who's going to buy me that beer.